is suing his ex-girlfriend, Erica Christian, for personal property and filing a false restraining order.
Court come to order. All rise.
Have a seat, everyone.
Case 2052, Henry versus Christine.
Thank you.
Welcome.
Mr. Henry, what you're doing is suing the defendant with whom you had a relationship for a period of time for the return of property that you had in an apartment that you once shared and for filing a false restraining order, a false police report.
Yes, Your Honor.
The defendant says that you never lived with her, that you damaged her front door, and you filed a restraining order against her that was false. So, Miss Christian, I think I'm going to start with you.
Yes, ma'am.
According to the papers that were filed, you and Mr. Henry did in fact live together for a period of time up until...
October 9th.
Shh! Up until October 9th of 1921.
Yes, Your Honor.
Of 2021, 1921, hardly almost the year of my birth.
Yes, ma'am.
2021, when he left.
Yeah, without a note.
Just a second. October of 2021. Then the information that I have contained in these papers indicate that he sort of came begging back, and that was in February.
Yes, ma'am.
Of 2022. And you took him back.
Yes, ma'am.
And he was living with you. You were living in the same apartment from February of 2022 until what you say in your answer is June of 2022, when for some reason you were looking through his phone. Now, you were looking through his phone because he was acting weird or whatever.
Yes.
That's June of 2022. You understand where I'm going, Miss Christian, don't you? Of course you do. So from February of 2022, February, March, April, May, for 4.5 months, Mr. Henry and you occupied the same residence.
No, ma'am.
Your residence.
No, ma'am.
Well, that's what you say.
No, ma'am.
Oh. Well.
He lived in his own apartment in Merritt Island. When we got back together.
Here we go. On February 15th, 2022, he contacted me and we got back together. He had his own place and never lived with me again. He would stay over occasionally and bring a few things to make himself comfortable. On June 21st, I went through his phone because he was acting weird. Where was he when you went through his phone?
He was asleep.
He was asleep where?
In my bed.
Okay. In the apartment?
Yes, I work at 6 o'clock.
In the apartment?
Yes, ma'am.
Of course, yes, ma'am. And I saw that he was setting up a date with the mother of his child.
Yes, ma'am.
I got upset, dropped off my son, and then came back home while he was packing. He told me he was taking my couch, TV, dresser, dining table, and everything in my apartment. So my next question to you is, who paid for the couch?
Me.
I'd like to see a receipt.
I don't have it.
Who paid for the couch?
It was a couple years ago.
Shh.
Sorry.
My brother, Adonis Glover, he's the one that gave me the furniture.
Just a second.
He gave me the couch, the love seat, the lamp, a few other things listed on that document.
When did he give them to you?
He gave it to me before me and Miss Christian moved in the first apartment.
So let's go back. Where was the first place that you lived with the defendant?
Cocoa, Florida.
Okay. From when to when?
From 2020 October to February, March 2021, because that's when her lease was up.
Were you both on the lease in that apartment?
No, I wasn't on that lease.
Just you?
Yes, ma'am.
And that's the first place that you lived together?
Yes.
And why did you leave that place, Mr. Henry?
She was relocating to Titusville. I helped her move into it, and I moved in as well.
Does that sound familiar to you? Be very careful what you say to me, because when I say I read the papers and I have my own preconceived ideas of what this case is about based upon 50 years worth of experience, be very careful what you say to me.
Yes, ma'am.
Great. Does that sound familiar to you?
No, ma'am, he is lying.
He is lying about what?
Adonis did not give him that furniture. Furniture was given to me, never was given.
Just a second. So we're not talking about the furniture now. We're talking about when you lived together.
Okay.
You first lived someplace together and then moved into another place.
Yes, ma'am.
So that sounds familiar. Am I correct that this is all about furniture?
No.
Mr. Henry, value of property She's not paying you for property, for furniture that was given to you that was secondhand. You have to understand that. If I find that it's your furniture, you're going to go and get it.
Yes, that's what I was hoping.
Just a second. You're going to go and get it.
Yes.
If you can establish to me that it's your furniture, you can keep it. You're not a married couple. I have a couple of issues with some things that I think that you did, because I actually think that you were together and he was packing his things, but then the police were called and you told the police that he didn't live there. Isn't that right?
Yes.
Okay.
Because
And just a second. And that wasn't true.
it is true.
Tell me where he was living.
He was living in Merritt Island. Whenever we broke up in October, from October to February, we broke up. He reached out to me the day after Valentine's Day. We started talking. He was buying me gifts to try to get back in my good graces. He was doing all this extra stuff to try to get back in my good graces. We got back together. He never did move back in with me. He always did live in his apartment in Merritt Island. I work at 6 o'clock in the morning till 12 p.m. Sometimes whenever I didn't have a babysitter, he doesn't have a job, he would watch my son. That's why he had a key. That's why he had to spend the night bag and all of that. He would bring over his clothes, shoes, PlayStation, anything to make himself comfortable to stay the night. And whenever the police were called, they made him collect all of those belongings and leave. They escorted him off the property, told him that he was not allowed back. They told me that
Well, that's because if that's what's happened, that's because they believe you, which I don't.
Okay. They definitely...
That's because they believe you, and I don't, because if he was trying to get back in your graces and he was living in his own space and you weren't back together again, why in the world were you going through his phone? If you were just a casual gal, and a casual gal doesn't let him stay with her son because, well, he was available and he wasn't working, so he watched my son and he stayed over. That all sounds like a whole lot of Who Shot John. And it was convenient for you to be able to say he doesn't live here. So all I want to know, Miss Christian, is this case is mostly about furniture, used furniture.
I also have a TV there.
Do you have the receipt for it?
Yes, I have a title.
I'd like to see it. You have a TV in the house that belongs to him?
So the TV was...
Just a second. That's either yes or no.
No, the TV does not belong to him.
Who does it belong to?
The TV was a gift from him to me that I ended up paying off because he told me that when he bought it, that it was bought cash. Whenever months later, I paid the TV off.
No, you didn't.
Just a shh. First, you're going to show me that you paid it off. I assume you have proof that you paid it
I
off?
gave him cash for it because I did not think that we were ever going to break up.
Well, you never thought you were going to break up. I thought he didn't live with you.
Like...
I thought he didn't live with you. You don't buy TV for somebody that you don't live with, that you're not going to watch all the time.
Eventually thought we were going to move into a house together, Your Honor.
Your Honor.
Oh, don't tell me what you thought.
The TV that was bought was before I even...
Okay.
It had nothing
That's
to
a
do-
PlayStation and
That's still
Nintendo.
property that's still at the apartment.
Okay. These are things that you say are yours,
Yes.
that you bought and paid for.
Yes.
Okay. All of these receipts.
All of it. No help.
Okay, so let's go beyond the point of now you're back together again, because that's what I believe. He's in bed, you're going through his phone, you find he's making a date with the mother of his child, you get annoyed, you take your son to another location because you know that there's going to be an argument. You come back, there is an argument.
Yes.
He wants to take stuff, whatever. Police are called. You tell the police he doesn't live there, they escort him out. He wants his property now. You're not married people. Whoever paid for the property or whoever was the recipient of a gift for the property owns the property. That's simple. You know, that's what the law is.
Raheem Henry claims his ex-girlfriend, Erica Christian, owes for personal property. Erica is countersuing for door damages and stolen property.
Okay, he has a Nintendo, a PlayStation, Sony.
Your Honor, he collected those whenever
Just a second. A queen mattress and foundation. And we have May of 2022. This is a TV, an LED TV.
That was my birthday present.
Nah.
What?
Okay, so I have titles to these things. You have titles or receipts for any of these things?
I don't have receipts for any of those things. He grabbed his PlayStation, his Switch, and everything whenever he left. The only thing that is in my apartment is the TV that he bought me for my birthday. May is my birthday. May 7th is my birthday. That was my birthday present that he bought for me.
Did you take your Nintendo?
No.
Did you?
I haven't had... Recently, that was something different. My storage unit was just broken into. This is why I don't have original documents. and she stole more of my property.
I don't know that. Did you file a police report?
Yes, ma'am. I
Okay.
did.
Did they ever find any of the property?
No,
Perhaps?
not right now.
Okay. The couch, whatever other furniture is there, is how old? I mean, it used to be used furniture, so it was.
Yeah, my brother Adonis got it when he paid for it. It was like a kind of like a bundle deal for the apartment, like a lot of furnishing, and I ended up giving him some money for looking out.
That was 2-3 years ago?
Yeah.
And it was used furniture at the time?
Yeah. It wasn't nothing like brand new out of the seal.
How much did you pay for the TV?
I got taxed when I was like at 15, almost to $2,000, because it's a 60-inch smart TV.
Okay. So what is it that you want, is my question.
I want a court order to go get the rest of my property.
I have to know what the rest of your property is.
Yes.
You have the TV.
The TV, I have asthma medication, I have plantar fasciitis.
I want to tell you something. She threw out your asthma medication.
I believe so, too.
She threw out your asthma medication.
Yeah.
What else?
I have crutches. I have.
You have what?
Crutches and certain things. I have
You don't
PlayStation.
Look, you don't need crutches. And the PlayStation you said was in the storage unit.
Yeah.
Well, I'm not interested in the storage unit. So far, I have a TV. What else?
My mattress, my bed, my
You don't
stuff
want
that I had
You don't
in the
want that.
apartment.
You don't want a mattress. Are you back with this lady now?
No.
Where are you living?
I've been living on the streets. I've been living out of my car ever since this been happening.
Where are you going to put a mattress?
I have a storage unit that I was going to just collect. I'm pretty much just trying to salvage what I can, because I have things that's sentimental, stuff from my grandmother passing away, things that I really can't put a price tag on. I just want to be able to get a court order to just get the rest of my belongings.
I don't know what the rest of. I have a TV. You have no place to put a mattress that's a couple of years old. So you really don't need that. I mean, I can give you an order to get your mattress, but what are you going to do with it? It's just going to cost you to go get it and to store it. So you really don't need it.
I don't need it, but I would like to still get all of my property back. Like the stuff that I paid for, because I worked hard. I furnished
I'm giving
my
you
apartment.
your TV back. You're going to get the TV. I haven't figured out what else it is that you really want to make this whole thing worthwhile. I'm not giving you any money. Do you want the mattress back? You paid for it. You're entitled to it back. I can give you an order for the mattress and the TV.
Okay. And I also have electronics, like from games, the controllers, just so much things that
TV, mattress, box spring. He's going to come and get it with a marshal, but he's coming to get it within 5 days from today.
So what if I pull up my bank statements to show that I gave him cash around the same time that whenever it was pulled up and everything? Because I did give him cash for the TV, for the bed, for actually more than he ever even put into it.
Let me explain something to you. Unless you have a check made out to him, I have a problem with somebody who lies to the police.
Ma'am,
I do. I have trouble with somebody who got very angry because her boyfriend, who was living there, watching her son, brought a TV, bought a mattress, bought a box spring, bought all of those things, and then you got annoyed that he was involved again with his child's mother. You dropped off your son someplace else to come back to have a fight with him. You did have an argument with him. Police were called. You said to the police, he doesn't live here.
Your Honor, he moved out.
He doesn't live here. That's what's here.
Your Honor, I never moved out.
He moved out in
We had a
October.
whole business together.
No, we do not. That business is in my name, and I have the receipts to that, too.
You have to understand something. I know what happened. I don't believe you.
Ma'am, I'm
you
telling
have
you
to.
the truth.
No, you're not. You're not telling me the truth. That when the police came, you said, he doesn't live here.
Yes.
He doesn't live here. Put him outside.
He took all of his belongings.
Did he take his...
October-
Oh, no.
May I finish? He took all of his belongings on October 9th. Whenever he left, without a call, without a text message, without anything, he broke up with me and left. He got back in contact with me in February. Mind you, we never lived together after that.
He was just staying over to watch your son when you got angry in June.
Whenever
It was June. It was June, 4.5 months later.
Which he would go back to his apartment. He would come. He never stayed more than a couple of nights consecutively.
Okay. He's coming to get his TV. He's coming to get his mattress and box spring.
Can we
You have a
talk about
counterclaim.
my counterclaim?
You have a counterclaim for damage to the front door.
Yes, ma'am.
Okay? Damage to the front door.
Kicked my front door down.
Okay. When did he do that?
The day after he was police escorted, they told him not to come back, and the next day he came back and kicked my door down right in front of the police officer.
So he came back with a police officer.
And kicked my door down.
Just a second. He came back with a police officer, and the police officer was there when he broke into your apartment?
Yes, and they were going to take him.
No, tell me what they were going to do. And they did nothing.
Well, they trespassed him from my apartment complex.
I'm asking you, what you're telling me is, madam, which is why I have problems with you right from the get-go. What you're telling me now is he came back to get his property. The next day,
He didn't come back
with a police officer.
Yes.
And what you're telling me, a police officer, and what, you live in Florida?
Yes.
What you want me to believe that a police officer saw him kick down your door, go into your apartment, take property, and did nothing. That's what you want me to believe.
He didn't not do anything. He was completely confused on who actually lived there.
You're telling me a police officer was confused.
I'm telling you the truth. They were very confused on
police
who
officer
actually
was
lived
Bring me
my
just a
escort.
second.
They were trying to figure out if it was my apartment, his apartment. I had to go get my property manager, bring my lease that only had my name on it.
You don't understand. The last place you lived with him full-time, your name was on the lease too. Only yours.
Correct.
And you lived together. So now you took his lease again, just in your name, and said, he's not on the lease, he doesn't live here.
We broke up though.
Okay.
And
All right. He's coming to get his
left.
TV. He's coming to get his mattress.
Miss.
Okay.
And I would
have
like to see
my
a police
iPad,
report.
my
I would like to
Chromebook.
see.
I also
were
have an
stolen.
iPad.
Just a
back.
second.
Okay.
You're done. You're going to get your TV, your mattress, and your box spring.
Has accused his ex-girlfriend, Erica Christian, of keeping his personal property. Erica claims he broke through her door and stole her belongings.
Now,
Yes, ma'am. I have my Chromebook, my iPad, my office supplies, things that were stolen from my company that whenever he kicked my door down and took things out of my apartment that day.
okay. Now let's get to the company. What kind of work were you involved with when you and the defendant lived together, Mr. Henry?
I did all the graphic design. I made the business cards.
Just a second. Were you involved in graphic design?
Yes. I actually went,
Just a second. Together.
no, it was mainly me.
And you did this over a computer, over a laptop?
Over a tablet, over my iPad.
So the business supplies that she's going to tell me about were for the graphic design business?
Yes. Some
You
of the
said-
supplies, but I never stole anything. I just had an iPad that I worked on, and I did graphic design on it. That was mine. I gave her cash for it. She found it on Amazon for me for a good deal. I was able to draw on it. She's never had access to it. There's always been my Apple ID on it.
Where is it?
I don't know. The day when I got escorted out, she came out of the apartment. I was going in to get the rest of my belongings, and she was saying, "I can't find my iPad. You have it." And I right then and there, I knew she found it and she took it and hid it. So the officer let me go inside to get my belongings. I looked in the closet where I had it wrapped up, gone. I walked outside and was like, "Erica, where's my iPad? I paid for that. I do work on it. That is mine." She said, "I don't know. It's gone. You must have it." Had this whole sob story about it. So still to this day, I have no idea.
Okay. What else?
My iPad that he stole the day that he broke into my apartment, my Chromebook that he stole the day that he broke into
You what?
my Chromebook, my laptop.
What else?
I have my printer that he stole. It's all right here, 600. Do you want me to just pass it to you?
Did you take a printer?
I wasn't
Shut
able,
up.
I'm so sorry.
I wasn't able to leave with anything because they made me have to go through a civil suit because she started claiming stuff and saying it was hers and it wasn't mine. So the officer
I
didn't
want
even
to
let
know-
me go back inside the apartment.
I want to know when you went in the presence of a police officer, whether you pushed down the door, kicked down the door or not. Unless I have a police report, I don't actually believe that a police
He
officer...
was my escort. I
Just a
actually
second.
met him.
Did you take any electronics with you when you left?
I didn't leave with anything.
These are text
Okay,
messages
George,
and stuff.
don't give me a whole bunch of papers. What I'd like to see is a police report or any other documentation that he took anything the day after you had him evicted from the apartment where he was living.
She didn't even have me evicted.
I have the receipts of the stuff that he stole.
He said he didn't take anything. He said the police officer was there, wouldn't let him take a printer. I mean, those are heavy electronics. And that was the only other time he was in the apartment.
He also checked my car.
No, he didn't.
Unless you have some sort of a police report for me, Miss Christian, I don't believe you. I think that you were really angry. I think that you were really angry because he left in October. You took him back in February. You found out that he was not being straight up front with you, and you were dishonest with the police, which is all part of being angry and felt that you were being taken advantage of. According to you, you was together so much so that he bought you a television set a month before you threw him out for your birthday that cost thousands of dollars. That's what you just told me.
Ma'am, he bought that TV in February for me for an early birthday present. He bought it for an early birthday present and told me...
He's coming to get, listen to me, he's coming to get his TV, he's coming to get his box spring, he's coming to get his mattress. It's a court order. It's a court order with a marshal in 5 days from today. Do you understand?
I also have
5 days from
my
today.
countersuit, my false police reports, the false injunction, everything that he did.
I have to tell you something. The same way that I'm not entertaining because it's over, this fib that you told to the police, which caused him to be... don't interrupt me. I'm not entertaining. You filed restraining orders against each other?
She filed...
Just a second. You filed restraining orders against each other. Is that right?
Yes, ma'am.
Do you have a restraining order against her?
Yes, but it was dismissed.
I said, do you have one currently? The answer is no.
No.
Do you have a restraining order against him?
No, ma'am.
Good. It's exactly what I thought. Because neither one of you have to say goodbye. You have to stop being angry, but you have to give him back his property.
I only wanted the restraining.
TV, mattress, box spring, 5 days from today. Counterclaims dismissed. We're finished with this case. Thank you very much.
This court is adjourned.
I think that it was unfair.
I'm pretty much just happy it's all over.
Broke up with me without even a text message, a phone call, nothing.
She just took it and ran with it, and she decided she was going to take matters into her own hands and be spiteful.
Very single. No more relationships for a while.
It's definitely time to move forward, move past it.
The good one is out there, but I have not found him yet.
It's just nice that at least it's over. It's a weight lifted off my shoulders.
Period.
Now,
Move
put a
on.
period. Now he has his TV.
Gonzalez is suing his neighbors, John and Heather Gilbert, for truck damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2095, Gonzalez versus Gilbert.
Thank you.
You're welcome.
Mr. Gonzalez,
Yes, ma'am.
you're seeking substantial amount of money to refurbish your car after it was hit by the defendant's car while your car was parked.
Yes, ma'am.
The defendants are seeking the same amount of money because they say that despite the fact that one of them did in fact hit your parked car, it was your fault. That's your defense.
Yes, ma'am.
Okay, who was driving?
I was driving.
Okay. Mr. Gilbert, on what date did this incident happen?
February 3rd,
What time?
about 5:30 in the morning.
Who was in the car with you?
Nobody. I was by myself. I was going to pick up my son
You were going to pick up your son from where?
from his mother's house to take him to school.
And where does he go to school that he has to be there at 5:30 in the morning?
He doesn't have to be there at 5:30. I have to leave at 5:30 to get him there by 7.
Do you take him to school every day?
No.
What was different about February 3rd?
His mother, stepfather, and the rest of their family was out of town. They had asked me to take him to school that day.
Just for that one day?
Yep.
The yep is not an answer.
Oh, yes, ma'am.
Yes,
Yes,
is an
Your Honor.
answer. Okay, so it's about 5:30 in the morning, and
I left my house. It was
Look at me.
raining. It was cold. It's pretty much the same route I take every day, not at that same time. I was approaching a stop sign at an intersection by the plaintiff's house, and I seen, I guess, either a reflection or what I thought were lights headed in my direction. So I swerved. And
okay, you're still traveling, so you're moving. Does somebody have a diagram of where this happened?
Yeah.
There it is. Okay. You were approaching a stop sign.
yeah, I was approaching an intersection.
So right on...
Were you there?
No, ma'am.
Sit down.
Yes, ma'am.
You were approaching an intersection.
Yeah.
It's a two-way road.
Yeah.
And it looks to me from that, is that an accurate representation?
Yeah, except for there was another vehicle on the other side of the road.
Okay, but it looks to me that you're traveling sort of in the middle of the road.
Yeah, it floods.
Okay, and a car is coming from something. You're not sure what.
Yeah, I wasn't sure what it was.
We're not sure what.
And I swerved.
And
I
you-
just got over to the proper side of the road.
And your car swerved, and when your car swerved, it hit that blue car that's sitting there. That's the plaintiff's car that was sitting in front of his house. Mm-hmm. Uh-huh is not an
Yes, ma'am.
answer. Yes, okay. Now, do you want to tell me what you did next?
I went through the intersection, turned around to follow what I thought might have been a vehicle headed my direction. And when I didn't see a vehicle, I took my vehicle home. I parked it. I got my insurance information, my driver's license, and I walked back to his house to trade insurance information with him.
Okay. You have a video of this incident?
Yes, ma'am.
From where?
From my surveillance cameras.
Is it set up for me to watch it
Yes, ma'am.
here?
Yes, it is.
Okay, I'm ready. That's your car, sir?
Yes.
Okay, let's see that again.
Notice how the truck is covered?
Okay, so you hit the plaintiff's car hard enough to push it up on the curb.
Speed limit is 30 miles an hour.
I've just asked you a question.
Yes, ma'am.
It looks as if you hit it hard enough to push it up on the curb.
Yes, I did.
But you told me a moment ago, Mr. Gilbert, and you just piped in that the speed limit there is 30 miles an hour. You said you were slowing down for a stop sign.
Said I was approaching a stop sign.
Well, when you're approaching a stop sign, you don't approach a stop sign at 30 miles an hour, especially if it's in a neighborhood that you've been in. But according to you, you drive that neighborhood regularly.
Yep.
However, not at that time. That's what you said.
Yes, ma'am.
So if you are approaching a stop sign, when I approach a stop sign, and if I know there's a stop sign there, I start applying my brakes a little bit before. Now, I do drive with some people who sort of like to play chicky with a stop sign, you know. Maybe the stop sign is going to move. Maybe it's going to become a welcome mat. So they wait until they get right up to it and put their brakes on. But that's not what you told me you did.
No, ma'am.
Okay, so now I'm going to say, if you were going very slowly, sir, approaching a stop sign, you wouldn't have hit his car with such force that you push him up on the curb. Okay, your defense is to this action, as I said, that he was parked and he had this car that was covered and it was parked facing the wrong direction, which is totally irrelevant as to was facing the wrong
according to
direction.
Texas state law.
It was on. It's covered over, so you don't know which direction it was facing, and certainly the light wasn't on it. If you're
I've passed this.
I didn't ask you for anything. You weren't there.
Yes, ma'am.
You weren't there.
Yes, ma'am. But
She lives in the neighborhood. She drives by it every day.
For
Just a
30
second.
years.
What do I need that for? I have a video.
Okay.
I have a
Can
video.
you see the stop sign in the video? No. You have no idea how close I was.
You just told me you were approaching a stop sign.
Yeah,
Would
there
you
is
read
a
that
stop
back to
sign.
me?
There is a stop sign.
Would you read that back to me? I was approaching a stop sign. Does he say I slowed down? I was approaching a stop sign. I don't remember.
It's about.
I didn't say. I did not
now
say.
you can leave.
I did not say I was slowing down.
Now you can leave.
I did not say I was slowing down. I said I was approaching a stop sign.
Okay, that's what I thought. But that's why we have Whitney.
Let's see, he says he was approaching a stop sign at an intersection by the plaintiff's house, and I can see either a reflection or what I see lights headed in my direction, so
Okay,
I swerve.
now I would like to see that video again one more time. I would like to see if I see something coming towards you. Actually, I don't see another vehicle coming towards you. Is that a truck parked there?
It's a food truck behind it. It's like catty corner to his vehicle. There's a food trailer there that had all of the light, like right.
A food truck on the other side of the street.
Yes, ma'am.
A food truck that you could see, but that's parked.
Well, I assume since there was no actual lights coming, I assume maybe that's what light reflected off of.
You don't assume anything. All you know is you saw something that made you swerve.
Yes, ma'am.
Whether it was there or not there. So am I getting the fact that your total defense is based on the fact that his car shouldn't have been parked there?
Yes, ma'am. Or covered.
Yeah, well, but that's a finable offense, Mr. Gilbert. That's a finable offense.
If it doesn't cause an accident.
No, I don't think it caused the accident. You caused the accident.
How did
You
I cause
caused the accident. This is an inert object.
According to my HOA guidelines, that vehicle is supposed to be in his garage. According
just a
to
second.
Texas state law, it's not supposed to be on the road.
And I'm going to tell you, I absolutely agree with you that that's a finable offense if his car is parked.
So
you're trying to interrupt me.
Okay.
That it's a finable offense. The question is his car being parked illegally the proximate cause of this accident? That's the question.
Would that be a fair? It is.
I didn't ask you a question unless you went to law school.
Huh? No, ma'am,
unless you went to law school. Am I in the realm? You're closer than that, was Palsgraf versus Long Island Railroad. His car may have been parked in the wrong spot. Yeah. If you had somebody that left a baby carriage with a baby on the street, which is certainly against the law and would be a neglectful act on the part of the parent, and if you happen to swerve up to avoid something and hit that baby carriage, you can't say that baby carriage is the cause of the accident.
No, the
You're the
carriage
cause of the
isn't.
accident.
No, the owner of the baby carriage is.
No, you are.
No, they are.
So,
How am
what?
I responsible for their baby carriage?
Because your car is moving, sir, and if you're approaching a stop sign, you're not supposed
If
to
the
be going.
vehicle wasn't covered, you
just a
could see
second.
the reflectors that are on it. That's what they're there for.
Reflectors on
Yeah,
what?
reflectors on the truck that's covered. They have headlights, turn signals, everything that's reflective that you could see. There was no reflectors or signals for me to see to know it was there.
You would have hit it whether it was covered or not.
Horse.
Very good. May I please see the...
That's horse. I
Please
wouldn't
see.
have hit it could I seen it.
Kevin, I want to see what he's got as far as work for the car. Okay, so this is clearly a project car, sir.
Yes, ma'am.
Yeah, it's people. It don't
so
run.
Get him out of here.
Let's go.
He's done.
I swear.
He's done.
Okay.
Thank you, Lord.
Oh, that makes my life so much easier.
Claims his neighbor, John Gilbert, hit his classic pickup truck. John is countersuing for car damage and harassment.
By the way, both the defendant and his wife have a counterclaim. Their counterclaim is for damages to their car and for harassment. Well, since neither one of them can keep control of themselves, the counterclaim is dismissed. I'm looking at this truck, Mr. Gonzalez. When did you purchase it, sir, and from whom?
In October of last year, I purchased it online.
Do you have the bill of sale from when you purchased it?
I don't have the bill of sale, but on the paperwork, I have the post on Facebook and how much I paid for it. It was for $8,000.
Okay.
I also have an appraisal on there as well.
I see the appraisal, but I don't have what it's going to take to fix the spot where he damaged the car. He damaged the car in this whole side end.
Yes.
I mean, he's not going to give you a classic car.
Well, I know.
That's not going to happen.
I know. I know
Okay.
that.
That's not going to happen. And certainly, you do understand that I'm not awarding you anything close, even though they're two obnoxious people, anything close to $10,000. You do understand that, Mr. Gonzalez. You're going to have to get this car fixed right now. I'm looking. Where is a invoice for either the work you had done or an estimate to fix that part of the car that he injured?
I cannot give that to you because
Well, then I don't have it,
the
sir.
vehicle is a classic. It's very hard to find that type of vehicle.
Well, then what you're asking me is to guess, sir.
Well, I can give you the rates as far as how much I'm
You
gonna have.
can't give me anything.
Okay.
You have to take the car in to somebody who deals with classic cars. So this is a 70-year-old truck, and it's certainly beat up. You had it covered for a long time. It shouldn't have been on the street. You do know that. And I assume that since it's not driven, you didn't have it insured.
Well, I took it out for Halloween, just for the kids.
Well, I mean, where do you suggest that I conjure up a figure of $10,000 when you have a car that's a year old that has never been driven, that you take out and it's a Halloween ornament? So let me explain this to you. I have to guess at a figure. I would be prepared to award you $2,000 to fix your car because I did see that it had to be damaged as a result of the damage to the defendant's car. If you feel as if you would fare better in your local small claims court where this case came from, because I have dismissed their counterclaim, I will dismiss your case without prejudice and you can take it back to the lower court. Take your choice.
I'll go ahead and take it from you. I know I'm not going to get anything from them.
Very good. Judgment for the plaintiff in the amount of $2,000. Counterclaims dismissed. Fix your car. Thank you.
This court is adjourned. Well, I didn't agree on the price, but with them kind of people, I'm not going to get my money back. It's time to get it repaired.
I think you have to be a certain kind of person to not take any accountability when you hit a stationary object. I'll admit, I think that it was probably a 90%, 10% split, 10% plaintiff's fault for parking on the street. I looked up the section code in Texas and did find that if you leave a car longer than 5 days on the street, you're in violation of a code. But like you tried to explain to the very hot-headed defendant, that's a finable offense. That doesn't mean you can ram into it with your vehicle and not be at fault. I just don't know how you take zero accountability after hitting a stationary object.
I don't know either, but that's, I think, a problem with a country that's grown up in the last 50 years, that it's never your fault.
Yep.
It's always somebody else. It's the state's fault. It's the city's fault. It's somebody else's fault. And it's sad because I know that there was lots of acrimony between the two of them without it. But they were hotheads. Is this the first time you ever saw me send somebody out?
A long time.
Yeah,
long time since I've seen it. Yeah. But when they're clearly not getting the message and they're being hostile, that's not the proper way to come to court.
No.
Especially when you're in the wrong.
All right, but they have to live near each other. I hope that they sort of get it together.
All parties, please step forward.
Amari Garcia is suing fellow motorist April Tarrant for damages from a motorcycle accident.
This is a case that's about an automobile-motorcycle collision. Each one of you claims that the other is responsible for the collision. Ms. Garcia, you were riding the motorcycle?
Yes, ma'am.
And you were in your car?
Yes.
Okay. And this happened on what date?
March 21st, 2022, around 3 p.m.
In what state?
California.
In the state of California, are you required to have insurance on a motorcycle?
Yes, Your Honor.
Just liability?
Liability if it's paid for in full, correct. Yes, Your Honor.
And were you insured on that date?
Yes, Your Honor.
And you were driving a car?
Yes.
And was your car insured on March 21st, 2022?
Not at the time.
So the answer is no?
No.
Did you have a valid driver's license on March 21st, 2022?
Yes.
From what state?
California.
What kind of car were you driving?
A 2011 Nissan Sentra.
Was it a new car for you, or did you have it for a while?
It's a new car. I purchased it 3 weeks prior to the incident.
And if you bought it 3 weeks before, how come you didn't have liability insurance?
I was looking for insurance, and plus, at the time, I hadn't received my paperwork. It was still in the other person's name at the used car dealership that I bought it from.
Your Honor.
I hadn't.
You know you're not supposed to be driving a car, Miss Tarrant, without insurance.
Yes, I'm aware of that.
Okay. You wanted to say something?
Yes, Your Honor. Thank you. I have proof that April Tarrant purchased her vehicle February 8th, 2022. She drove uninsured for 41 days, and it was not from a lot. It was from someone off the street. I have the proof for that.
I'd like to see it.
Yes. Oh, thank you. For $2,050.
Well, this car that you registered, the selling price was $2,050, according to this.
No, it wasn't. And
well, I'm going to show you vehicle and transfer law. This is 2011 Sentra, and it was signed, but it's LLC. That's his company.
Okay.
So it wasn't off the street, but it said the selling price was $2,000. That's what this says.
I don't have my paperwork in my car.
Want to show this to her? I just want to get some basic facts first, and then I'm going to go to the incident.
But that's and
No, the person, the seller.
And I have my paperwork in my car.
Yeah, but you understand that that's
I understand
what
what you said because it's right there. Yes.
Okay, we have a diagram. This happened on March 21st, 3 o'clock in the afternoon. You had no insurance, and you were traveling in the bike lane.
No, that is not true. I shared the lane of the car on the right. I would never go into a bike lane. That is disrespectful to the road and riders.
Just a second. Are you allowed to share a lane with a car and a motorcycle?
That is your right, yes.
I know Foothill. Is that where you were?
Yes, Your Honor.
And at a certain time during the day, Foothill becomes very trafficked.
Yes.
And the cars sometimes get stopped because there's a light, right?
Yes, Your Honor.
Go over to there, Miss Garcia, and show me, please, where you were positioned before you say that you were traveling in the same lane as a car.
Your Honor, I was directly behind this car.
Okay.
Directly behind.
You were directly behind that car.
Yes.
And that car was stopped.
They were slowing to a stop.
No, they were stopped because they had to have been stopped because that's why you went around him.
They were slowing to a stop. By the time I got around here, they were stopped. I didn't want to veer into here. I was slowing down. I was around 25 miles per hour. This lane at the time was too close. So I shared this lane on this side.
Miss Garcia, I got it, Miss Garcia. You want me to appreciate the fact that you wanted to get around the stopped car and you wanted to continue to go straight, correct? You weren't turning. You wanted to go straight.
I was going straight, correct.
And so you want me to picture in this tiny mind of mine that instead of going into a perfectly clear bike lane, you inched your way at 25 miles an hour in the same lane as a stopped car.
Yes,
But
This diagram,
I find that hard to believe, Ms. Garcia.
Your
I really
Honor,
find that hard to believe. You may be in the right with regard to this, but I find it hard to believe.
the
because
roads are very wide. I have the actual police photo document of that.
I'd like to see it.
Yes, Your Honor. Right here.
And I'd like to see the
This
police
thick.
report as well. Is there a police
It's
report?
attached to this.
Fine. Because as you were traveling straight, the defendant was making a left turn. She was making a left turn because the two cars there were stopped, and those were the only two traffic lanes there. Now, I don't know whether she could see whether it's a motorcycle or a bicycle traveling in the bike lane, but what happened was she was making a left turn. According to this, you went into her passenger side. Is that correct?
Mari Garcia is accusing fellow motorist April Taryn of damaging her motorcycle. April claims Amari was illegally driving in the bike lane.
Who was in the car with you, Miss Taryn?
My son and his girlfriend.
One of them had an injury.
Yes. My son's girlfriend, she was in the driver's passenger side. And while I was turning into the lane, I just felt a crash and saw glass going into my car. And then she was cut.
Okay, and you had an injury to your knee.
Yes, I have several injuries. And I have photos as well.
You understand, Miss Taryn, that the police interviewed witnesses. The witnesses were in the stopped cars.
Yes.
And at the end of all of their interviewing process, they determined that you were the cause of the collision. That's what it says.
And I don't.
It says that you caused the collision by violating Vehicle and Traffic Law 21-8001, failure to yield when making a left turn. I determined the cause based upon the parties involved and the physical evidence. That's what the police determined. Okay, well, then that's an easy, based upon the police report, because each of you were going to tell two different stories about what happened that day. Police were there, they looked at the physical evidence, they looked at the injuries, they looked at the damage to the roadway, they interviewed independent witnesses, and that was their determination.
I understand, Judge, but the police report had some inconsistencies where, like, she was driving in the bicycle lane, which is against the law. And what I was doing, I was making the left turn, as you know. And these two front cars, which one of them was a witness.
Yes, that car paused to let you make a left turn.
Yes, both lanes. And I was.
No, you said both lanes.
Both lanes paused.
Well, that's what you say.
Yes.
That's what you say. That's not what this says.
See, but they both did. And as I was
But I'm just telling you.
No, I know.
Yeah,
that's
but
what
I'm just telling you. That's not what this is. That's
Exactly.
what you say. There was nothing that prevented those two cars from going.
Exactly.
There wasn't a traffic light. There wasn't a stoplight at that spot.
Yes.
And there was heavy traffic.
Yes.
So it's your responsibility to make sure if you're making a left turn that you have to yield to all oncoming traffic.
And
so the fact that you didn't see her is really not relevant. And as long as you understand that this police report supports Miss Garcia's claim that you caused this accident by making a left turn when you shouldn't have been making a left turn, that's what this says. And that, at the end of the day, it's an accident. That's why it's not called an on purpose. It's called an accident. Neither one of you anticipated it. As far as I'm concerned, Ms. Garcia, you're entitled to be compensated, but I'm going to suggest this to you. If I'm driving a motorcycle, which I would never do, just for me, I think it's wacky. I think there are enough crazy people driving around that I like about 2,000 pounds of steel around me, so that if somebody who is not paying attention and there's an accident, I like to be safe. My first car when I was 17, all my friends were getting these cute little cars, that were convertibles, and my father bought me a 15-year-old blue and white Cadillac sedan. It was so embarrassing to drive around in that car. It was a boat. Oh, come on. Everybody else is getting these cute little Corvettes, even if they're used ones. And my father, who loved me a lot, said to me, sweetheart, if you get into the accident, I want you to come out unscathed. And this ensures that you got a shot if you get into an accident. And I feel better. So I'm just telling you, if you're going to drive a motorcycle, don't take shortcuts. I know this place on Foothill, and I know what happened here. You wanted to go, there was no reason why you couldn't. That's why you drive a motorcycle, because you can get into tight places. But you look like an intelligent young woman.
Thank you, Your Honor.
Don't take chances. That was a chance. It could have been a lot worse. What was the damage to your motorcycle?
I have pictures. Would you like to see them, Your Honor?
I would.
I did look it up. Lane splitting motorcycles is legal in California, based on the California Highway Patrol.
Okay, no, I see the pictures. So where is the motorcycle now?
I no longer have it. The towing company, they sold it. They sold it for $70 they claim, and I got hit with collections afterwards. I have the bill for that if you'd like to see that.
How much did you pay for it?
$6,407.
Do you have the bill?
Yes.
I'd like to see it.
For my motorcycle, what I paid for, correct?
Yes, what you paid for it. What are you driving around in now?
A 1995 Chevy Baville.
Atta girl! Atta girl. Okay. I'm giving you the value of the motorcycle.
Thank you, Your Honor.
Which is $6,407. I'm not splitting whose fault this was, actually, but I'm not awarding you any punitive damages for her. She had injuries in her car. You were slightly injured, but both of you seem fine now. I don't think that you were careful enough when you were going straight and around that car that was stopped. But the defendant didn't have insurance, and she was cited by the police for violation of a traffic law. So I'm giving you the cost of your motorcycle.
Thank you, Your Honor.
Judgment for the plaintiff.
This court is adjourned.
So I actually ended up, after the car had made impact with me, the bike went that way. I went up into the air.
It was really frightening.
I hit the ground. I hit on my elbow.
I've never experienced that before.
I was really scared. I thought, like, oh, this is it. My legs are out.
And like I said, I was being cautious, and
thankfully I wasn't.
But it ended up in that kind of situation.
Definitely more safely as far as better gear, and, you know, like she said, don't take a shortcut or anything of that sort.
So I looked up lane splitting, and in California, it's one of the few states that allows it for motorcyclists. It does say inexperienced riders shouldn't attempt it because, like we see, it's very easy to get hit or for someone not to see you if you're splitting between lanes, but it is legal, so she wasn't in the wrong by lane splitting, but I think it was a sticky situation. You're behind a car, someone's turning.
What does it say if you're injured?
It does say on the Highway Patrol website that you're splitting at your own risk, so any injuries that happen are at your own risk.
So they say if you are lane splitting, it's not illegal, but if you have injuries as a result of an accident, if you're lane splitting, you're responsible for your own injuries.
It doesn't say it in a legal term that I could really stick to, but it says it's risky. We're acknowledging that it's risky. You have to assume the risk of lane splitting if that's what you choose to do.
Boyfriend Willie Albrecht for filing a false police report and harassment.
Court come to order. All rise.
Have a seat, please.
Case number 2068, Automatis versus Albrecht.
Thank you.
You're welcome.
Mr. Albrecht, I'm going to start with you, sir.
Yes, ma'am.
You are the current live-in boyfriend of the plaintiff's ex-wife?
Soon to be.
Of the plaintiff's wife.
Correct.
Mr. Adamas' complaint is that as a result of you making a call to the police, he was defamed when you said that he was trespassing. It was a false call to the police, and he wants to be compensated to the tune of $2,500. That's what the case is about. So in order to make this whole thing in context that I understand, how long have you been living with Mrs. Adamas?
Since June of 21.
How long do you know her?
Since January of 21.
Have you ever been married?
Yes, I have.
When and for how long?
Previously to April of this year, I was married for 15 years.
So you were married when you moved in with Mrs. Adamas?
Yeah.
Legally?
Legally.
Did you own your own home?
I did.
With your then wife?
Correct.
Did she stay in the house?
She did.
Does she have a boyfriend?
Yes, she does.
Do you like him?
No, I do not.
Does he live in the house?
Not at this time.
Did he ever?
Yes, he did.
And you didn't like it?
No, I did not.
So I want you to understand that there is maybe a reason why the plaintiff resents you living in a house that he owns with his still wife, and you're living there. Do you understand?
I do.
Because you sort of have the same situation. You're kindred spirits. Just a minute. Actually, you're kindred spirits.
Except my 15-year-old son also lives with this young man.
So who cares?
Oh.
Well, that's all right. But you understand why he might be annoyed.
I do, but
Okay. So now, understanding all that, I want you to tell me, because I'm not totally sympathetic with you, sir, because if you and your wife are divorcing, you're entitled to move on with your life, and so is she entitled to move on with your life. Where do you live? You live in an apartment?
I live in a condominium.
Okay. How long have you lived in the condo?
I've lived when we separated March of 2021.
And who do you live with?
I currently live with my
No. Who do you live with is the question.
my older son,
And how old is he?
19.
And how many bedrooms are in the condo?
2.
And what about you? Have a girlfriend?
Yes, I do.
Ever stay over?
My house? No.
Do you ever stay at her house?
No.
Does she live with her children?
Yes.
And is she divorced?
Yes.
And she stayed in the house?
Yes.
You see how all these things go? It's just, as the world turns, it's just what happens. I've been there. Understand it all. Can either make it hard or difficult. Who pays the mortgage on the house?
Paid off.
Okay. So you have one teenage child, your wife has the other.
Yes.
And how close is the judgment to divorce to being finalized?
Not close.
Not close. Is that for financial reasons or custody reasons?
Financial.
Had to do with the house?
Yes.
Okay. How much is the house? I'm just fleshing this out.
Speculating.
Probably because I'm a little bit of a yenta. Behind this purple robe is a little bit of a
You know, with the housing market, being a CPA, you know, it's hard to say, you have to do, but I would say somewhere.
Why don't you give Sarah the address of the house and we'll tell you what this estimate is.
California.
While she's looking that up, tell me when you and your wife purchased it.
2006, August of 2006.
And during the course of the marriage, were you employed all the time?
100%.
And what about your wife?
100%.
So you were both employed and both contributed to the house. Fair statement?
Yes.
Great. Okay.
It's 4 bedrooms, 2.5 baths. The estimate is 552,000.
And just for my own curiosity, what's the rub about the house?
The rub
Come
about
on, it's simple.
The rub about the house is she's now went in and spent an ungodly amount of money on fixer-upper after I moved out and went into a massive amount of debt. The house was fully paid off, and she's now in massive debt. She's put in fixer-upper.
No, don't look at her.
Okay, that's
look
what
at me.
Okay.
So she's fixed up the house after you moved out.
Correct.
And?
It's not a problem.
Just a second. So what's the problem?
There is no problem with the house. Meaning that we're still debating who's actually going to end up with the house. We haven't decided.
Well, whoever wants to be in the house buys the other one out.
Exactly.
For $260,000.
Correct.
Okay? It would seem to me that would be easy.
I think so.
Okay. Now that I've satisfied the yenta in me, I'm getting back to the case. All right. You called the police. This incident, according to what I read, Mr. Adamus, happened on November 5th.
Correct.
You went to the house to pick up your son.
Correct.
Okay. Was that a meeting that had been arranged before?
I have visitation every 2 weeks.
Every 2 weeks when?
Every other weekend.
Well, so was this a weekend?
Yes, that was one where I was going to go pick him up.
Okay. Had you spoken to him?
Yes.
And so he was expecting you to come at a certain time?
Absolutely.
What time?
Approximately there, we'd arranged about 7:15, that 7:15, 7:30 that night.
Okay. And you had visitation fixed by the court, and you had been enjoying that with your son for a period of time?
Correct.
Okay. What happened when you got there at 7:15?
Well, on that particular visit, my wife had taken his key to the house, and I had...
No. I told you, don't look at her.
Oh, okay. Sorry. Oh, okay.
I'm getting sympathetic with her. I just want you to know that.
Okay.
7:15, you went to pick up your son, and you were annoyed because your wife had taken your son's key away from him.
Correct.
And you thought your son should have his key because he was 15.
Yes.
And?
So at that particular time,
No, don't look down.
Okay, look at me. I went into the house. I'd never been in that house since I moved out, and so I wanted.
How did you get into the house?
The door was open.
Okay, the door isn't wide open. You mean it was unlocked?
Unlocked.
Okay, so let's not say the door was open.
Okay,
the door was unlocked.
Correct.
Door was unlocked. You don't live there anymore. You live in a condo.
Correct.
Okay, did you ring the bell?
No.
Knock at the door?
Yes.
Nobody, but there's a bell.
Answered.
There's a bell.
There was a bell.
There's a bell.
Yes.
Didn't ring the bell. Open the door. Now, open the door.
Yes.
Your house, I own half of it. I'm going to ask my wife a question.
Yes.
Keep going.
Walked into the house. At that particular time, she is sitting there with my son. At that particular time, I asked her to get a copy of the key, and we became into an argument. She didn't want me to have a copy of the key. And I tried to explain to her, without a copy of the key, he can't get in the house if I drop him off at odd hours, and you don't have to be home. So then she got upset. At that point, then I never met Mr. Albrecht before this time. He comes storming down the stairs. Mr. Albrecht is then, I think Mr. Albrecht's coming to beat me up. He is storming down the stairs. I've since learned that Mr. Albrecht...
Just stop.
Okay.
Just pay careful attention to me. So far, you're in the wrong.
Okay.
Now, let me just tell you.
Okay.
So far, from a legal perspective...
Right.
...and a common sense perspective...
Okay.
...you're in the wrong. I'll explain why in a second.
So I walk into the house.
We got past that.
Okay.
We got past that. So now you want a copy of the key, and she says no. I don't care if you want to give it to your parakeet.
Okay.
You're not entitled to a copy of the key.
Okay.
Let's start right there.
Okay.
And let's start with my first point is if you're going there to pick up your son for a prearranged visit,
yes,
you don't walk into the house. You have a 15-year-old son. A 15-year-old son has a phone.
I tried to call him, yes.
Oh, you tried to call him. What happened?
He said he was there, that he said...
Be very careful what you say to me.
Okay, he was
called
there.
Your son.
And I called my son, be ready to go. He said, okay, I'm ready to go.
That was at about 7 o'clock.
Yes, approximately.
What do you mean, yes, approximately?
Yeah, I was probably on my way to pick him up. And so when I come up there, I call him on the phone.
Okay, he's ready to go.
Yes, are you ready to go?
Okay, so you walked in.
Okay.
You had no right to enter the house.
Did not know that.
Well, you had no right to enter the house. You knew that your wife changed the locks.
I did not know at that time she had changed the lock because the door was open. I had not been
No. Listen to me. You went there because... Mr. Adonis, you have to be a two-process thinker, sir, before you give me a lot of baloney.
Wrongfully called the police while visiting his own house.
Okay, if you needed a copy of the key to a house that you partially own,
yes,
you would have had a key to the house.
Correct.
You didn't need a copy to make because you would have had one.
Okay.
So you knew that your old key didn't open the house. Otherwise, you would have said, your mother took away your key. I'll make you another key from my copy.
True.
True. Of course it's true. So, so he called the police and he said you were trespassing.
No, he didn't say that at all.
What did he say?
He said he told me I was trespassing. Then he called on the phone. And when he's on the phone with the police department, he is telling them that I am now committing domestic violence. Now, that is a very serious charge. I mean, okay, we can debate about my access to the house, but when you call the police and say that I'm committing domestic violence, which is a crime in the state of California, that's a game changer. So
I want to ask you a question, Mr. Adonis. When you walked into the house, and you saw your wife and your son, I want to know, when you walked in, uninvited,
True.
Your first words were, I want a copy of the key. That's what you said. You said, I want a copy of the key. Would you read that back to me, please, Whitney?
I'll go with that.
At that particular time, I asked her to get a copy of the key, and we became into an argument.
So now you're in an argument, and you're a trespasser. Your case is dismissed. Goodbye. Goodbye.
Okay.
This court is adjourned.
Very, very shocking.
She's absolutely correct, as she usually is.
I had no idea this was going to blow up into World War III.
Because he's all about winning. He didn't get his way. He was throwing a temper tantrum.
I feel that he's just trying to do whatever he can to keep me out of the picture.
He lives by his own rules.
He just simply wants me out of the way so he could take over.
Let the courts decide.
It's always so unfortunate when people divorce. I mean, the story is this. I could have written this script without even listening to the people. But they have two teenage boys, 15, 19 years old. One's chosen to live with the father, one's chosen to live with the mother. Clearly, the son said to him, Mom took away my key. She clearly took away his key for a reason. I didn't even want to get into what the reason was, but clearly she took away the key for a reason. Otherwise, she doesn't look like an unreasonable person. Her boyfriend doesn't look like an unreasonable guy. And he was flexing his muscles. And the fight is over the house, because I gather that's the only real asset they have. Yeah. Anyway, unfortunate when people don't realize that they have to love their children.
Ryan Hastings is suing his former roommates, Peyton Kammer, for a security deposit, personal belongings, and filing a false restraining order.
Mr. Hastings, you and the defendant were roommates? I'm not quite understanding.
Yes, correct.
Clearly, whether you were roommates or in a relationship. What was it?
It was just roommates.
When did you start to be roommates?
In September of 2020.
Did you know each other before?
Yes.
How?
We were just friends that met at a party and hung out often.
Starting when?
That was in December of 2019.
And what made you decide to room together?
We were both looking for a place to live, so since we both needed that, we found this apartment together.
2 bedrooms?
Correct.
And you moved in with animals,
Correct.
I understand from the complaint.
Correct.
Cats?
Yes.
How many?
I had 2.
I had 2.
I didn't ask you anything yet. You had 2. And Miss Kammer had 2. Any other animals?
No.
So you started to live together during COVID.
Correct.
Were you working?
Yes.
Was Miss Kammer working?
Yes.
What was the rent on the apartment?
It was $13.65.
And you each paid half.
Correct.
So far, correct? Was everything okay in 2020? September, October, November, December?
As far as rent?
No, as far as the living arrangement.
Oh, in 2020, yeah, we just had many squabbles, but overall, we were just fine.
I'm going to ask you the same question. In 2020, everything okay?
No.
What happened in 2020?
It was emotional warfare since I moved in with him. There was arguments with everything, even simple things like cleaning the dishes, just nonstop. I was terrified of him living with him. I couldn't bring anything up without it being an argument.
Okay, so prior to moving in with Mr. Hastings, where did you live?
With my parents.
How old are you?
I'm 21.
Is this the first time you had an apartment?
Yes.
And how far away were your parents from this apartment?
Probably like 10 minutes.
If you were terrified, you should have moved home.
I wasn't allowed to.
You weren't allowed to because?
Because I wasn't allowed to live with my dad and stepmom because they moved into a 55 and over neighborhood.
When?
They...
If you tell the truth, you don't have to have a good memory.
They moved in a little after I moved into my apartment. I moved into my apartment to prepare for them moving out.
I just don't want to hear drama. If you had fights over who's going to clean the dishes I don't want to hear terrified unless you're terrified. And if you're terrified and you're 21 years old, you go back to where you came from, to your parents' house. If you're terrified, may not have liked it, but that's just kid drama. So, squabbles in 2020. Your lawsuit says that she disposed of your belongings. She filed a restraining order.
Yes.
As a result of the restraining order, you were evicted from the apartment.
Yes.
It was a false restraining order. You hired a lawyer to appeal the finding of the judge.
Yes.
That you had harassed her because this restraining order was based on harassment.
Yes.
May I see a copy of it, please?
I have a copy of the restraining order.
Of the order or what it was based on?
It said it has the whole thing. It says what it was based on.
Yeah, I see what she has. It doesn't look like it was what it was based on. You do a write-up of what it was based on.
On the front page in a little box, it has a little description of what happened.
Okay. So the judge who heard this case, and I'm assuming everything in this write-up is true. On the above date, which was the 7th of September 2021, on the above date and time, defendant and the plaintiff engaged in a verbal argument over household chores. The defendant then made comments to the plaintiff that he would go crazy on her and raised his fist. The defendant stated this multiple times and started shaking in anger, causing the plaintiff to be in fear for her life. And you had a hearing on this?
Yes.
You had a hearing on this. You told this to a judge?
Yes.
Yes.
I want you to tell me what you told the judge, or did you tell the judge anything?
I told the judge that I was raising my voice, but I was standing a good amount of distance away from her at the time, and that I was shaking because I wasn't being listened to, and that was it. There was no physical interaction there, only verbal interaction.
His former roommate, Peyton Kammer, owes for a security deposit and personal belongings. Peyton is countersuing for rent and emotional distress.
Now, tell me, did the judge say to you, how would you describe shaking in anger because you weren't being listened to?
Can you repeat that question?
I don't know how you were shaking. You mean you...
I was shaking as in I was shaking just because I was angry. I wasn't being listened to. I was trying to keep my composure. So I was just shaking.
Well, that would frighten me. Actually, I don't know whether I'd put you out of your house, but that would frighten me. Mr. Hastings, where are you living now?
I just moved into a new apartment.
With whom?
Myself.
Better?
Yes, and my cats.
Perfect. Yourself and your cats. Great. Now, I'm going to tell you, Mr. Hastings, if that happened to me with a man who was larger than I was, that might frighten me if he appeared out of control. So I'm dismissing that part of your complaint, which seeks damages for a false restraining order.
Okay.
What you actually just testified to me, and I took everything that she said in her complaint against you. I didn't even have to ask her. I wanted to know what you told the judge.
Of course.
Then it was a reasonable issuing of a protective order, just to make sure that it appeared to me what you were testifying to is that she couldn't tell the difference whether you were composing yourself or whether you were out of control. Okay, so it was...
May I interject and just say that the restraining order was repealed and remanded, saying that the court did not find sufficient evidence to impose the order. And
whether it was or not, I don't care what I'm not sitting as an appellate court.
Okay.
I'm sitting as a trier of fact for the first time in your civil action. And what you told me, in my judgment, was sufficient for a judge to say, you know, I don't want to preside over an assault case or a homicide case. This guy says he was shaking. She says he was shaking in anger. You say I was shaking to try to maintain my composure. Well, I'm not going to worry about them. Let him go find someplace else to live, which is what he did. So I think that that's reasonable. Money owed for return of security deposit. Now, he was put out of the apartment. He put in security deposit.
Correct.
And he was put out of the apartment. How much security deposit did he put in?
$682.
Are you still living in the apartment?
I am.
Okay. When he moved out of the apartment as a result of this restraining order, was there any damage in the apartment that he caused?
No.
Then you have to give him back his $682 because any damage that would have resulted since he moved out would be your damage, okay? That's fair enough. $682, that's your security deposit, sir. Return of belongings. Okay, so when you were told that you had to vacate the apartment, tell me what belongings you left in the apartment which you think she still has, which belong to you.
I do not believe she has anything of mine left in that apartment.
Well, what do you think she owes you for?
I am seeking the money for those items because they were thrown away.
What items?
So I had a bed.
Just a second.
Yeah.
You had a bed and there was a major flea problem in the apartment as a result of your cats.
Correct.
Okay, she threw away the bed. What else?
Okay, there was a Nintendo Switch.
Do you know what that is?
Nintendo Switch? I never found that. I believe he took that the night with him.
Okay, she didn't have it. She didn't throw it away. What else?
I also had a hookah that was in there.
What, a hookah?
Yeah.
Do you have his hookah?
No.
Go. What's next? Okay, if you have to think about it that hard.
I'm sorry.
Sir, we're finished. She owes you back your security deposit.
Okay.
That's $682. You have a counterclaim. Most of it is nonsense. You counterclaim for emotional distress. Forget that. Only one emotionally distressed usually in this room is me. Money owed for the month's rent, for a final month's rent. What is that?
He didn't pay the month of September. He was late on it.
The month of September.
But that would have been the $682.
Was he there in September?
September 1st would have been the day that the money was due.
No, when did he vacate the apartment as a result of your restraining order?
September 7th, when the night of the mistake, but he was late on rent often.
$682, that's what he gets.
Yes.
As he gets a security deposit back. Your counterclaim's dismissed. We're finished. Thank you very much.
Thank you.
This court is adjourned.
I don't really disagree with anything. Everything went perfectly the way I would have hoped it went.
I'm glad I got my security deposit back, but I could have definitely been compensated for the items that I lost.
I mean, he got a little money out of it, but way less than he thought he would. It's a good day.
Sometimes I can get anxious, but I would not hurt anybody physically.
I hope he gets some help.
Me and my cats are the best trio.
You know, I remember from a very early period in my life when I started college that I wasn't really good at having a roommate.
I think you must have passed that on to me.
I did, especially one that you don't love. You know, it's hard enough to live with somebody that you love.
Mm-hmm.
You know, they get irritated. You know, she said they fought over dishes and not doing the dishes. Well, you know, you've lived with us, so, you know, I have that argument all the time. But I love him.
Yeah.
It's very hard to deal with somebody schmutz that you don't love.
Got to be careful and pick someone you really think and cross your fingers and toes.
Actually, Sarah, I don't think you should pick anybody. I think that what you should do, if you can, is live in a shoebox by yourself, if that's all you can afford. Yeah. You know how many roommate cases we've done just in the last couple of years?
All with stress and aggravation intertwined immensely.
Immensely, and that's without romance involved. I mean, this young man, who looks like a perfectly reasonable young man and very honest, said he told the judge that he was shaking. I said, well, describe to me what you were doing. And he shook. And
I would say
that's
that's a
crazy.
little out there.
She was getting under his skin. There's no question she was getting under his skin.
Middle of COVID, everyone's inside.
You could tell she was getting under his skin. She was terrified. You know, she's 21 years old. Yeah, a little dramatic. Anyway, I think it ended okay.
Hendrickson are suing their former employer, Christopher Ricks, for unpaid wages and vandalism.
Court come to order. All rise.
Seat, please.
Case 2094, Joyner Hendrickson versus Ricks.
Thank you.
You're welcome.
I think that I'm going to start out with Mr. Joyner. Who is that? That would be you, because we start with you. He came in later to this scenario, is that right?
Right.
So let me try to understand, Mr. Joyner, what it is that you're suing the defendant for, considering what you wrote to me in your complaint. You were looking for a job. Whatever business you had went south, and you didn't have any money.
That's not true.
Well, let's see.
It was said like that, but we did not lose a
After losing my jewelry business.
Yes, ma'am. That's not right.
Well, that's what you signed in your complaint.
Yes.
So I can only go by what you signed in your deposition. That you lost your jewelry business, that's what it says. Anyway, you were looking for a job. The defendant has a theater, among other businesses.
Yes, ma'am.
And you sought out the defendant, Mr. Joyner?
Yes, ma'am.
Tell me how you sought him out.
I was vending in a coffee shop. I was vending my jewelry. It's not a lost business.
Would you just get on to how you met him?
Definitely. So I was vending there, and I saw at the theater Pride Weekend. So I had called Chris Ricks, said, hey, is it okay if I come up there and vend my jewelry?
Just a second. So you called him. Was his name on the poster? How did you find him?
I just called the theater's number, and he answered.
Okay, so you weren't calling him, you were just calling the number.
Yes, ma'am.
So you asked him, can I come and sell my jewelry at your theater? When was that?
That was Wednesday, June 16th, 2022.
Okay, and you were having some sort of an event?
Yes, ma'am.
Did Mr. Joyner come and set up his jewelry booth?
They did, in fact.
Were they charged for that?
No, I
Nothing.
did not. I
So-
just simply offered the space. They kind of told me their backstory and that they were having financial troubles, and I was trying to do a good deed for the community.
Okay, so you were not charged for the space?
Right. Yes, ma'am.
And you went up there on what date to sell your jewelry?
We started Thursday night, June 17th, 2022.
When you say we, is that you?
All three of us, yes.
Okay, so did you sell any jewelry?
A little bit.
So not much, not enough for the three of you spending a day on the
Yes.
17th. And then how did it come about that you sought out a job from Mr. Ricks? Because you did seek a job. On what date did you ask him if there was any work?
Thursday night. Thursday the 16th.
And what were you supposed to do?
Supposed to bartend, open, close.
That's not accurate.
I'll get to you.
And
What
run
were you
concession
supposed
stand.
to do?
And run the concession stand. Bartend, close, open, and run the concession stand.
During what hours?
4 p.m. that day till 12 a.m., 1 a.m. that night. Could not really remember.
Okay, and did you do that?
Yes.
And you weren't selling your jewelry at that time?
I was going off and on. So anytime he had called me for a different job, I would take that. Sorry.
So the answer is you were doing both.
Yes, ma'am.
So you were doing your own business and doing whatever task Mr. Ricks asked you to do.
Yes, ma'am.
That was on the 16th. And did he pay you for that work?
Yes, he ended up
And
paying
just a
us.
second. And how much did he give you?
Gave us $264 for that weekend.
Not we.
I gave me $264 that week.
Did he work that weekend?
Yes, we all three worked that weekend.
Doing what?
Everything.
Well,
we
Mr.
opened.
Hendrickson is not suing for any wages from him other than for the painting that he did later. I'm asking you, what did you do for him and when and how much did you get paid?
I did opening, closing duties for him. I ran a bar.
For how many days?
4 days, Your Honor.
4 days.
In the beginning, but I did pick up more stuff whenever he called me for more opportunities. So he would be like, hey, we have jam band tonight. So I would say, okay, I could work.
Okay, so you worked, say, until June 20th, you said, for 4 days, and then you would work after that period of time?
Yes, ma'am.
When did you stop going to the theater for the purposes of doing anything for Mr. Ricks? Month and day?
Oh.
One of the things you're supposed to have, Mr. Joyner, when you come to court, and if you're suing for wages, is you're supposed to have it right here, right in the front of your brain. What date you started, what date you stopped, what hours you worked, what you did. That's what you're supposed to have. Do you understand? Okay. Mr. Ricks, on what date was the last date you saw Mr. Joyner at your theater doing anything?
Saturday, June 25th.
So it would be a fair statement that certain days you saw him between the 16th of June and the 25th of June.
Yes, ma'am.
Now, you told me about the 16th that you started working part-time because you were back and forth between your own business and doing something for him, for which actually he gave you free space to sell your jewelry. Now, when you go someplace, you usually pay for space to sell your jewelry, right?
Right.
Well, I mean, I know that because I've had hundreds of cases involving people who rent space in a theater or under a tent or in a yard so that they can sell their jewelry. He gave it to you for nothing.
Yes.
And you're back and forth doing little errands for him on the 16th. Like what? 16th, while you were selling your jewelry. Tell me what you did.
We worked the jam band for them that night.
Not a we. I don't want to hear a we.
I worked the jam band that night. He has like a jazz band that comes in and performs.
And what do you mean you worked?
I worked the concession. I opened, closed, bartended for him, anything that he was calling me over to do.
That's a little too loosey-goosey for me.
No, I can tell
That's
you
a little
exactly.
too loosey-goosey for me. Okay, let's go. What did he do, if you remember, on the 16th?
On the 16th, 17th, and 18th, that's when they had their jewelry set up. He did not work my concession stand at all. He did not work for me that time at all.
That's not
He
true, Your
started
Honor.
working.
Don't speak. Do not speak. Do you see I asked you questions? He was quiet. Now it's his turn to speak. Now you have to be quiet. You understand?
He worked Sunday, June 19th from 9 to 2, which was 5 hours. That was brunch. He worked June the 22nd. They were late. They arrived at 3:12.
You said they arrived.
Both of them came that day.
On the 20s?
On June the 22nd.
22nd.
Mm-hmm.
Was that the first time that both Mr. Joyner and Mr. Hendrickson came together?
To work for me in a theater capacity, yes.
Okay. And that was June 19th?
No, that was June the 22nd. But actually, I misspoke. I apologize. They both worked June 19th for brunch. They both worked June the 22nd. On June the 24th, he had a text meltdown, and then he came to work and worked 5 to 9. I have their hours exactly. 5
to 9, and that's just Mr. Joyner or both of them?
They both came on June the 25th, Your Honor.
And worked from when to when?
On the 25th, which is Saturday, he worked from 5:20 to 10:30. He passed on the concession opportunity where he could have made more money.
No, but he worked doing what?
He trailed me. I was trying to teach him managerial type cash in, cash out, et cetera, and the business situation of the theater, because that's what he proposed to me that he was educated to do. And so
You mean managing a theater?
Yeah, just kind of helped me with open, close duties, overseeing that tasks are done by the other employees, et cetera.
Okay, so it sounds as if he and Mr. Hendrickson worked for a limited number of days.
Correct.
How many days in total?
In the total project, which is painting.
No, not
just the
painting.
theater. Just the theater.
in the theater.
Joyner worked 4 days at the theater, and Harland worked 3 days at the theater.
Okay, and how many?
4, I beg your pardon.
4.
Yes, ma'am.
Your last day of work, that was the 25th of June?
Yes, ma'am. At the theater.
I'm talking
18.
about only at the theater.
I think he worked 18 hours, just at a quick glance here.
18 hours during the 4 days.
Yes, ma'am.
And Mr. Hendrickson, how many hours did he work on? You don't have anything in front of you, Mr. Hendrickson, so I assume you have nothing. No physical evidence, is that right?
Correct, Your Honor.
All right, good. How many hours?
Just under 12, actually.
Say 12 hours. So one worked 18 hours, one worked 12 hours. Do you have any data to indicate that those hours are wrong?
No, ma'am.
Okay, great.
And claim their former employer, Christopher Ricks, owes for unpaid wages and vandalism. Christopher is countersuing for damage to his apartment complex and slander.
Okay, how much were you paid, Mr. Joyner? Because part of it is your wages that you're requesting for working in the theater. How much in total did Mr. Ricks pay you?
$264.
That's for the theater work?
Yes, ma'am.
And how much, Mr. Hendrickson, did Mr. Ricks pay you?
$204.
Sarah, do math for me, would you please? 18 into 264 and 12 into 204. Now, on what date, Mr. Joyner, because this is where it gets sort of fuzzy to me. So far, this is what I'm getting, that the three of you were trying to start a business that was marginally successful in selling jewelry. So far, do we agree on that?
Yes, ma'am.
And as part of selling your jewelry, you approached the defendant, and it was really a cold call. You called a regular number, not Mr. Ricks personally, and told him your story. And he said, well, if you want to come down, I'll give you free space to sell your jewelry. And that was within his theater area.
Yes, ma'am.
So you would say that was very nice of him. And you worked for him, and he showed you the place, he showed you the books, he showed you, you started to do other things. Now, at some point, this is where I go a little fuzzy with you, Mr. Joyner, and maybe you can help me understand you. So you have someone who's been nothing but nice to you so far. On what date did you file a complaint with Alcohol and Beverage Control?
That was July 5th, 2022.
So let me figure this out. So you worked for him at the theater until June 25th. On July 5th, is that what you told me?
Well, after the 25th of June, so we had kind of like a weird period where we were trying to figure out if we still wanted to finish the apartments for him. And
No apartments. We haven't gotten to the apartments yet. I'm going to get to the apartments because he asked you to paint apartments. You went over there, and that's another part of your lawsuit. Just a second. Sarah Rose, how much did Mr. Joyner make per hour?
$14.60.
Minimum wage.
And Mr. Hendrickson
It's 11 in Arkansas.
would be 17 an hour.
And he made 17 an hour.
Correct, for 12 hours at $200.
But there was no
Those
actual
hours are not correct.
there was no actual documentation. Like we did not have a clock in, clock out. But the 18 hours is not correct, though. We have
Just
no
a second.
data. We
Just
have
a
no
second.
data.
You have no data.
Right.
He does.
But there's no it's not actual fact. It's not fact.
I don't know whether it's factual. How do I know? You're supposed to keep track.
Yes, ma'am.
You're supposed to keep track.
We're not the business owners.
Just a second. You want the money.
Theater.
Right now, he's paid you more than the minimum wage for being around. I mean, the theater ran for how many years before they worked for you for 6 days?
Been about a year and a half. I bought it during COVID.
Okay, and this was your first time working in a theater.
Yes, ma'am.
Yeah, so you had no fund of information. He wasn't paying you for expertise. He was paying you for those few days, and you were following him around, closing a stand, whatever you were doing, and you were paid more than the minimum wage, which is, I assume, more than you made selling your jewelry for the 3 days you were there.
Yes, ma'am.
Right.
Right.
Okay. I'm still going to wait for this answer, because at some point after you stopped working for him at the theater, and after you had mulled over some information that you thought you had acquired while you were working for him, I want you to do a step-by-step why you contacted the authorities, because he does have an alcohol license, right? I assume if you have an alcohol, if you contact, don't look at each other. Just look at me. I'm actually the nastiest one here.
Agree.
Well, so alcohol beverage control. So what information, sir, did you give alcohol beverage control that caused the investigation?
Your Honor, he was not the one that called them. I was.
We both called. So what happened during the time that we were working those 4 days, he would serve other people alcohol. He would get on our asses about IDing people, how to sign the papers for ABC, everything. And I made sure to take a picture of the number. I didn't take a picture of the whole document itself.
What are you talking about? What
The
document?
the ABC paper. Whenever we had to sign the paper saying that if we didn't ID someone and the ABC came in and found out about it, we would be fined and we would be held responsible, not Chris. We had to sign those papers.
Okay.
For that stuff.
So you signed the
but
papers.
during that, after we signed that, we noticed Chris was still giving out free alcohol to people, pouring it, wasn't even checking people's IDs. So I called the ABC and I said, I think there's suspicion that he's giving minors alcohol. Because there were people there that were 19 years old that were coming up to us saying, oh, well, yeah, we're 19, but we're cool with Chris and stuff like that in ways. Like they had a way with Chris or whatever, friends with Chris. We just started working there. We don't know the regulars. We don't know what the life is like.
I'm just trying to think of why you would do that for somebody who was, forget whether I believe you or not, forget the loosey-goosey of what you just told me. Maybe he said,
We actually have a recording that he admitted to giving one of our 19-year-old employees alcohol. Because he said...
And? Just tell me, and? I want to know why you called them on July 5th. You were no longer there. Did that have to do with the painting? Was that before or after you started painting?
That was after we started painting.
Of course it was after you started painting. Now, so let's go to the second part of your lawsuit. Second part of your lawsuit involves the work that you both did for him. You have an apartment complex, Mr. Ricks.
Correct.
And that apartment complex contains how many apartments?
20. I bought it as a rehab.
And they-
It was completely vacant. And
At the time that you asked them if they wanted to paint it, it was vacant, all 20 units?
correct.
Tell me, how did you approach Mr. Ricks or he you about this house painting job?
We were trying to get away from all the stuff that we were seeing and hearing at the theater. So we asked if he had other jobs for us, and he said he had apartments that needed to be painted last week, and that if we could get in there and finish them, great.
Okay, now I'm going to come back to what you just told me. You just told me that you saw things at the theater that he served somebody that you know who was 19 alcohol. And that was very distressing to you. So distressing that you said to him, do you have any other work for us?
It wasn't just that
Just a second.
instance.
Just
no,
a
ma'am.
And claim their former employer, Christopher Ricks, owes for unpaid wages and vandalism. Christopher is countersuing for damage to his apartment complex and slander.
Okay. Did he take you over to paint the complex in handcuffs? Did he take you over there in a van? Did you ask him for additional work?
He's the only person really in Hot Springs, Arkansas that we
sec-
felt like we could relate to and feel comfortable working for.
I asked you a very simple question. Give me a very simple answer. Did you ask him for more work?
Yes.
And did he say, I have an apartment complex that needs painting?
Yes.
And did you agree on a price?
Yes, ma'am.
And what was the name of the last person that you did painting for? House painting?
I did it for my parents when we built our house, but that's...
Very nice. I also painted a room once in my dining room when I was 24 years old. I actually thought I did a pretty good job. I would not hire myself out as a house painter, but because I painted my parents' living room when I was 12. So the answer is you had
The reason why he was asking us to paint because he couldn't find someone else to paint for him because he wasn't paying people.
I didn't ask Noah to paint.
Shh.
That's correct.
Just a second. Sir.
I was not asked to paint.
Sir.
No.
Mr. Joyner, you know what your problem is? Your problem is you were dissatisfied with what you saw at his theater. And then you went,
shouldn't have reported it to the ABC?
now I'm speaking. You were dissatisfied with what you saw at his theater. While you were there, working at the theater, you did nothing about it. Zero. Even if it was true, you did nothing about it.
We didn't want to lose our jobs at the time, Your Honor.
You didn't have jobs at the time. You stopped working for him on the 25th of June. You didn't call alcohol until July 5th, you said. So you were no longer working for him in the theater. So it didn't start to bother you, really. June 22nd, June 23rd, June 24th, June 25th, the 26th, the 27th, the 28th, the 29th,
correct, Your Honor.
30th, all the way up until July 5th.
The ABC report was not just filed by me, and it wasn't just on July 5th. There was also another instance where it was filed earlier, but that was with them,
Just
and
a
there's
second.
no evidence about it.
Just a second. You filed July 5th.
Yes, ma'am.
Now you're going to tell me what happened with the painting, because you finished the painting kerfuffle happened in July. Is that right?
Right.
And it was after the painting kerfuffle that you called alcohol beverage. After the painting kerfuffle.
Well, it was
So
during. It was during.
What?
It was during, kind of, almost.
You're getting the feeling that
It
I'm
wasn't
not
just me that
you're
filed
getting,
the report
you're
with
getting,
ABC.
Well, just a second. You mean one of these other people who was also
Harlan
jobless?
filed.
I don't care.
So we shouldn't
Nobody
have, we
was
shouldn't have
fired.
reported it at all.
No,
So we shouldn't have
no, I'm
reported it?
trying to get to your motive, sir. If it was so abhorrent,
My motive? I have
don't,
no
don't
motive.
speak.
I
Don't
am just
try,
owed
don't
what-
try to speak
work
over
for.
me. Don't try to speak over me. That
No, I'm trying to
doesn't
fight for what I'm
work.
owed.
So far, you're not owed a thing for the theater. Now we're getting to the painting. I'm just trying to see what motivates somebody. And I'm not excusing the fact that if Mr. Ricks serves alcohol to minors, that's not a good thing to do. He can get into real difficulty. They conducted an investigation as a result of the calls.
Absolutely.
All I have to ask you is this. Do you still have your liquor license?
Absolutely.
Okay. Was it ever revoked?
No. And I've had multiple in the state of Arkansas.
So you're not owed any money for the theater. Now we're going to get to the paint. When did you start painting in the complex? Date.
June 27th, 2022.
6/27. Did you paint there 6/28?
Yes,
Did you paint there alone or with Mr. Hendrickson?
Mr. Hendrickson.
Is that correct, sir?
Yes, Your Honor.
Did you paint on June 29th?
Yes, Your Honor.
Did you paint after June 29th?
No, Your Honor.
So you painted there for 3 days. Is that correct?
Actually, 5 days that I was there. I started on the 23rd.
I was there for 3.
And did you work the 23rd?
I worked the 23rd through the 29th.
Just
7 days.
23rd, 24th, 25th, 26th, 27th, 28th. So you worked weekends.
Yes.
It's not.
Did you work weekends?
I worked the 23rd through the 29th, 7 days.
Well, 7 days. Just a second. Pay attention to me. 7 days includes a weekend,
Yes.
Saturday and Sunday. Did you work
Yes.
Saturday and Sunday?
Yes, I did, Your Honor.
Not Sunday.
I'm going to go back to you. Did you work Saturday and Sunday?
I worked the morning of Sunday and I left 3 hours
All right.
after getting there.
Okay, so forget Sunday. Now, how many hours did you work on each of those days, Mr. Hendrickson?
I do not remember the hours for the days, but I calculated all the hours together and it was 52.
Let me understand what you just said to me. You don't know how many hours in each day, but you calculated them together and came up to 52 hours. Would you repeat what he said to me? Because it's mind-boggling to me.
He said, I do not remember the hours for the days, but I calculated all the hours together and it was 52.
How do you calculate all
sorry,
the
I think
Let me
need to be
ask
able
my
to
question, sir. How do you calculate up to 52 when you don't remember how many hours you worked each day?
Looking at the text messages and seeing when I got there and when I left, because I texted him when I opened the doors and when I locked up.
Well, then you know how many hours you worked.
Technically.
What?
Technically, yes.
What do you mean technically yes?
Because they're not completely correct. I didn't text him right when I got there, and I didn't text him right when I was leaving. I texted him when I got home or after I had started.
Okay.
Giovanni Costello is suing his former friend, Jacob Knapp, for dental and medical bills.
Court come to order. All rise.
Have a seat, please.
Case 2110, Costello versus Knapp.
Thank you.
You're welcome.
Mr. Costello, you and Mr. Knapp were out drinking in the park.
Yes.
Date and time.
The date and time was around 3 a.m. and it was on 9/11 of 2021.
And you've known Mr. Knapp for how long?
Roughly 9 years. We started off playing high school baseball.
And when had you first met up on September 11th?
I can't remember the exact time. I would say around maybe 7 p.m.
Where?
At a bar over in Old Town Pasadena. We weren't meeting up.
Just a second.
Yeah.
So you were in a bar in Pasadena, 7 p.m., just the two of you, or were there more people?
No.
How many were there in the whole group?
I had around 5 or 6 people in my group, and we went
All
to a
friends?
Bar. Yeah.
And you?
He wasn't a part of that group.
But you were at the bar?
No, ma'am. I was at work when he contacted me.
Okay, so you were at the bar starting at 7 with your friends. He wasn't there.
Yeah.
Okay, what time did he join you?
It wasn't, I couldn't tell you the exact time.
Approximately.
About an hour later.
At the bar?
Yeah, but it wasn't a text or anything like that. He just happened to go to the same bar.
No, ma'am. What ended up happening from the start, I was at work. He contacted me via text. I don't
You
have
have
any-
that text?
No, ma'am. I tried to erase the whole memory from my mind, so I deleted all the pictures and all the text
Oh, well,
messages
that's
from that.
unfortunate.
Yes.
That's unfortunate. I've never done that, by the way. You know, wanted to erase something from my mind, so I didn't just say I'm not going to think about it anymore. I've never done that. Did you ever do that, Sarah?
I have not.
You have not. And she's pretty efficient with text messages. Did you ever do that?
Never have I done that.
No. Well, you must be unusual, sir. Okay, so you met at the bar. What time did you get there?
Well, my shift ended at around 9 o'clock.
What time did you get to the bar?
10 o'clock.
And when you got to the bar, you met Mr. Costello.
Yes, ma'am.
He had a few friends with him. How long did you stay at the bar?
We were there till 12.
Okay, so Mr. Costello, you had been drinking from 7 until about 12.
Correct.
The answer is yes. Yes, of course. And what's your drink of choice, sir?
Beer.
What else?
The first bar that we were at doesn't serve hard alcohol, so it was just beer there.
Okay, so from 7 to when were you at the first bar?
Yeah.
From 7 to when?
7 to when? Till
To
12.
12.
Yeah.
So it's
But I
7
was
to
driving
12.
At the same time as well.
Okay, so from 7 to 12, you were drinking beer.
Yeah.
And then where did you go at 12 o'clock?
After 12 o'clock, we ended up going to another bar in Arcadia.
Okay, and you stayed there from when to when?
From 12 to closing, which is 2 a.m.
And you were part of that group?
Yes, that's when I initially met the group.
At the second bar or
At the
first?
second bar, yes.
Not at the first bar?
No, ma'am.
Okay, so you got to the second bar, you were there about, you said you were there at 10 o'clock.
Yes.
So they weren't there when you arrived?
They were there when I arrived, yes.
Well, he said that, I thought he said he got to the second bar at 12 o'clock.
I arrived at the bar at around 10 o'clock, ma'am.
And you got there at 12 o'clock.
Yeah.
Yeah. So by the time you all got together and left the bar, you had all been drinking, you for a very long time and you for a shorter time.
Yes, ma'am.
So from 10 to 2, so 4 hours. And what's your drink of choice?
10 to 12, Your Honor. I apologize. 10 to 12.
Where did you go at 12 o'clock?
12 o'clock is when we had all decided to go to a park, kind of a low-key area.
No, he said that he went to a bar between 7 and 12. Am I correct, Whitney? Did he say? 7 and 12. He said you were at the bar, first bar, between 7 and 12, drinking beer. That's what you said.
Correct.
You said the first bar only served beer. Is not an answer. Yes,
Yes,
is an
it does.
answer. You say at 12 o'clock, you went to a second bar where you had alcohol between 12 and 2.
Yes.
Yes?
Correct.
You got to a bar at 10 o'clock.
Yes.
Which one? The beer bar or the alcohol bar?
I finished my shift, like I said, at 9, and I showed up at the bar at 10 to meet up with them, to try to rekindle an old friendship.
Okay. Yeah. I actually don't care about that. All right, so partially you got your story straight, partially not. Anyway, you were two drunks. Now it's after 2 o'clock, and you decide to go to a park. How many people went to a park, and what park?
It was the same amount of people that I was with from the start.
And you were along at the park?
Yes, ma'am. Yes, it was.
Okay, did you take any beers to the park, or you went without them? You took
Yes.
beers to the park. The answer is yes.
Yeah, the main reasoning of going to the park was after the bar had closed. Jacob mentioned to the group that he had beers with him. So that incited us to go to the park and have some
To continue
beers with him.
drinking.
Exactly.
Yeah.
Yes, prior to me showing up, I did stop by 7-Eleven and pick
Okay, so you had beers with you, and you were at the bar.
Yes.
Nice, very good. Now you get to the park, you're drinking beers. Now you're going to describe what you say is the assault that you suffered at the hands of Mr. Knapp. Now, I want you to know my feeling before you tell me the story.
Okay.
I usually don't get myself overly exercised about what drunks do in a park. Do you understand?
Mm-hmm.
I know that you may be all exercised about it, although I'm not exactly sure you're all exercised about it. So if you really are, I'm going to listen to you. If you're not,
Yeah.
we just eliminate this case. Do you understand?
Yes, ma'am.
Claims his former friend, Jacob Knapp, owes for dental bills after being hit in the mouth with a beer can.
Okay, go. You're in the park, drunk.
Starting at
He's
the
in the
park, yeah.
park, drunk.
Yes.
And
To state I was not drunk because I was driving my witness here.
I
my
want to
friend
tell you
Maureen.
something. If you were drinking
Yeah.
from 7 to 2, you were
I
drunk.
hadn't been drinking the whole time that I was
Let's
there.
go. Let's go.
Okay. So going into it, I was sitting at a park bench with Maureen here, and then I had another two friends that were on the other side, and we're hanging out. They had the two across from me got up. They went further into the park, and I was sitting with just her alone. And I was just about to show her a video off my phone. Next thing I know, I get hit in the face by a beer. After that occurs, I reach to my mouth to see something's wrong there. And I feel that like a part of my tooth is missing.
Okay, and that's what we're talking about.
Yeah.
That's the assault that you're talking about.
Yeah.
And you allege that Mr. Knapp was the one who threw the beer bottle.
Yes.
Okay.
It was a full beer can.
A can.
Yeah, not bottle.
Did you report this incident to the police?
I did not take it to the police
Just
because...
a second, I'm just asking you.
Oh, sorry.
The answer is no.
No.
I disagree.
Disagree that he went to the police?
With his story.
Okay, I'll get there. Okay, so now you get hit in the face with a beer can, step by step. You look down, you look at your tooth.
Realize it's chipped. I say out loud, my tooth is chipped. She doesn't.
Don't tell me
believe it at
not
first.
about she. Just you.
Just me. I noticed it was chipped, and then after I announced that it was chipped, several of my friends, I guess, went towards him, and I
Well,
don't
you
know.
didn't tell me anything about him. You didn't tell me. You just said you got hit in the face with a beer can.
Yeah.
That's all you said to
And
me.
he was the only other person that was standing right there, besides her sitting
Just a
next to me.
So you didn't see him throw the beer can at you.
There was no one else there.
I'm just.
Yeah. Oh, sorry. I didn't see him throw it at me, but there was never a case of.
No, you didn't.
Of anything.
That's all.
Yeah.
You didn't see him throw it at you.
No.
Okay, go.
From the park, Your Honor?
Take it from
All
the
right.
park.
So
Now I got 2 drunks in the park, maybe 3.
there was actually more than just 3 of us surrounding the table.
Just a second.
Me and him.
Go slowly.
Okay, sorry.
Slower.
Let me take
I
it
don't
down a
know
notch.
table. I have no idea what you're talking about.
So, as he was saying, we were sitting at a park bench. I had brought the beer. The beer was next to me. He had asked me to toss him a beer. And that's plainly what
Okay.
I did was I underhanded him lightly a beer to him. And in his defense, he's saying he wasn't drunk, but it definitely was apparent that he was. When
And
you lightly
anybody who's been
toss a
drinking
beer,
from 7 to 2 in the morning is drunk.
Yes, ma'am. So I lightly tossed him a beer, and unfortunately, it was dark enough to where he had missed, and the beer had hit him in the face. Which, after immediately, I started to apologize to him, stating that I didn't mean to, but it was apparent he was looking at me and did not catch the beer. So personally, I think everything he said to you right now was
that's your story. You tossed him a beer
Yeah.
because he asked you. He said, toss me a beer.
Yes, Your Honor.
And it was dark,
Yes.
and you were drunk, and he was drunk.
I wasn't drunk, Your Honor. I had 4 beers
No.
within the time of
No.
10 o'clock till
I'm not-
when this incident happened.
You know, I'm not real comfortable with that, sir.
Okay.
Because according to you, you had been drinking for 4 hours. And not only were you drinking for 4 hours, but you brought extra alcohol to have in the park. By the way,
Which was a
by the
closed
way,
container.
where do you live and what's
In Pasadena, Your Honor.
in California? Are you allowed to drink alcohol in parks in California?
I'm not certain.
Well, let's find out. Open beer cans in city parks in California.
That's a no.
So after...
We're not talking yet.
I'm sorry. Excuse me.
Drinking alcoholic beverages is a prohibited activity in parks and park areas, according to the Pasadena City Park rules.
Thank you. This park that you went to, what's the name of it?
I'm not sure. It was up the street from the last bar we were at.
Okay. Now, did you, Mr. Costello, and the defendant, immediately after this event, did you communicate with him via text or email?
I texted him, I think it was roughly a couple of days later.
Okay. I'd like to see the text.
I have that.
That's all I
The
want to
other
see.
thing I could-
Don't say anything else.
Okay.
Just show me the texts that you sent him a couple of days later.
There it is.
Okay, thanks, Kevin. I'd like to see these texts from your phone, and I'd like to see all your text messages starting September 14th
It's right here.
of 2021. No, sir, you have to understand. What you said to me here, what you gave me, is 2 texts a year apart. I want to see the texts to him
There was nothing.
after September 14th. You mean he didn't respond at all
The
to
next-
this? I don't believe that.
My next thing that I did was I sent a letter through the mail, and I have that here, and I have proof of it where I had it so where he had to sign for it, and I have the receipt for it as well.
What date?
That one, I can pull it up right here.
I'm sorry, what letter? I never received a letter.
Just a second. So what you're telling me is that I'm supposed to believe that after you sent this email on September 14th, which is 3 days after the event, He never responded to you, and you never sent a follow-up email or text.
That was the letter. And in the letter I gave him...
Shh, just a second.
Okay.
Oh, here, take this back. It's nonsense. I don't want to see something prepared for litigation, sir. You said you had a document that you sent to him that he had to sign for. If you sent him a letter, return receipt requested, then you have a return receipt requested with a signature on it. That's a document that you prepared 2 days ago.
I have the receipt in here.
Let's get it.
Okay.
I never signed such document.
Just don't shout out again.
Yes, ma'am.
It's annoying, and I'm annoyed enough with this case.
I'm sorry for being so unorganized.
Me too.
Yeah.
I'm sorry you're so unorganized too, or disorganized.
Oh, here it is.
Great.
Certified mail. They're stuck to the back one.
This was sent April of 2022. I want to see what the response was. There had to be a response.
I never got a
since
response
September
from
14th, 2021. There had to be a response.
I never got a response from him.
Kevin, show this to Mr. Knapp and tell me if he recalls this text message.
Your Honor, no, I do not remember getting this text.
Why would you respond a year later? I know from the past, dealing with Mr. Knapp here, he tends to always, being friends, whenever get into an altercation or argument, he unfollows me, blocks me on everything. Okay. So there's a possibility by that text message not going through.
I don't deal in possibilities, sir.
I sent the text message, and I have proof of there. It was delivered, and I never got a response from him.
I'm just asking.
Yeah.
Sir, this incident happened September 11th. You have to understand, I think that if that's what happened. I tend to believe that the defendant did not just willy-nilly take a can and fling it at your face. I want you to know that I don't believe that.
Giovanni Castillo has accused his former friend, Jacob Knapp, of hitting him with a beer can. Jacob says Giovanni asked him to throw it.
Okay, it is more likely than not that you were sitting with this lady who, according to you, you were supposed to drive home. That's what you said 5 minutes ago. So you were supposed to drive home, which means she was trashed, because that's what you said. You said, I wasn't...
This was the arrangements from the very beginning of the night.
Okay. Do you understand? So we had a whole bunch of trashed people. And I am more likely to believe the defendant when he says you said to him, toss me a beer, and it accidentally hit you in the face.
My questioning is that the...
I don't answer questions.
Okay, well, where the beer was placed on the table, I don't understand why I would have to ask him to toss me a beer when I can simply reach over and grab one myself.
I don't know either. But it sounds more likely to me than not that it was his beer, he brought it there, and you said to him, toss me a beer. And you failed to catch it. Now, that doesn't mean that the defendant isn't at least partially responsible for the stupidity of that night. But you have some responsibility, too, because I really don't believe that he left the bar. He was angry and frustrated over something that you had no idea what he was angry and frustrated over, because you were all sitting together. And he just, out of the blue, took a beer and threw it at your face. I don't believe that. Do you understand?
If I could show you a picture here, you could see that if he just simply tossed me a beer, I don't understand how a beer can could chip my tooth the way that it did.
Just a second. It can. It can.
Okay.
I can eat a biscotti and it can chip my tooth. Biscotti, that's a cookie, a very hard cookie. And have. I mean, I could chip my tooth on my grandmother's steak, it was so hard. But certainly from a beer can. So I don't believe that you're blameless. What was your dental bill, sir?
I have the statements here.
While he's looking for that, you understand that if you were sitting there and instead of a bunch of beer cans and the plaintiff said to you, you know, that gun that's in your pocket, toss it over to me, I want to take a look at it. And you did. You took a gun out of your pocket and you tossed it over to him, and as you were tossing it over, it accidentally fired. Would it be his fault if he got shot?
No.
No. Whose fault would it be?
Mine.
Right. Because you weren't supposed to do that.
Right.
Because it was potentially dangerous.
Of course.
Well, same thing with a knife or an explosive device.
Right.
Or something very hot, like toss me a cup of coffee in a container and it splatters. So you don't do what anybody asks you to do if it's not a smart thing to do.
Right.
Unless you're drunk. Unless you're drunk.
Your Honor,
then,
if I may.
Yeah.
Coming from a baseball background, such as me and Gio did.
I don't care about your baseball background. There's no question, sir, that you acknowledge you threw it at him. And I'm telling you that your excuse is that he asked me to do it, so I followed the fool's directions. I'm telling you, he's going to pay part of his dental bill because I think it was partially his responsibility. But if you acknowledge that you were stupid enough to throw the beer can in his direction, you have to be partially liable. You're two drunks, that's what happens. So don't get so drunk and go to a park. How old are you?
27.
27 is old. And you?
28, Your Honor.
28. You know, old enough not to be so stupid. You know, you can figure 17, 18-year-olds are so stupid. At age 28, you should be doing something constructive. I assume you work?
Yes.
What kind of work do you do?
I'm a chef.
And you?
I'm a lumberman, Your Honor.
Okay, so you're both gainfully employed, letting off a little steam. That's fine. But if there's a problem that develops because anybody is not operating on all cylinders because of alcohol, you have to take responsibility. What was the dental bill?
My dental bill came out to $2,342.
Can I see that, please, Kevin?
I have this here. I'll give you both.
Was any of this dental bill covered by insurance?
On the dental, no.
Okay. Anything else?
My wholeheartedly truth is I didn't ask him for a beer. I had no problems. I was avoiding him the whole night for the most part because from the past, Jacob has had a way worse drinking problem than I've ever gotten to. I went out that night solely to have a couple drinks, hang out with friends. The night went longer than expected.
Very nice. Judgment for the plaintiff in the amount of $1,171, which is half of your dental bill. You pay half. Don't get drunk. You're too old to get drunk. I don't believe that he maliciously threw this at you. I think that you asked for a beer, tossed it at you, and you missed. That was his stupidity and yours. We're done here. Thank you very much.
Thank you, Your Honor.
This court is adjourned.
All I did was I underhand lightly tossed it over to him, and that's really what happened.
I did nothing wrong to deserve to get a beer thrown in my face like a baseball.
Unfortunately, he chipped his tooth, and so it was unfortunate.
I said, hey, Jacob, look, you chipped my tooth. Look what you just did.
No more drinking in the parks, guys.
Not to do it again.
I think this situation is the exact reason cities like Pasadena have rules about drinking alcohol in parks, because like you always say, it's not an on purpose, it's an accident. But a lot of times there are certain things that can increase the probability of an accident happening.
True.
And I think drinking at 2 a.m. in a park probably is one of those things.
That's true. So so many times rules and regulations don't seem to have any substance of reason behind it. But this certainly is an example of why.
Angela Landy is suing her former employee, Alishani Wyatt, for stealing clients and breaching their employment agreement.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2112, Landy versus Wyatt.
Thank you.
You're welcome.
Miss Wyatt, when did you become an esthetician?
I was licensed as an esthetician in March of 2021.
Okay. Miss Landy, this is what your case is about. You hired Miss Wyatt for your business. You have a spa business? Is that what it is?
Yes, Your Honor.
How long have you had the business?
I've been in operations as an S Corp since 2016. I worked for myself as a sole proprietor since 2009.
How many employees did you have in 2020 and 21?
In 2020, it was during the pandemic. We were shut down most of the time. In 2021, there was up to 5 employees, not including myself, Your Honor. It was 6 of us total.
Does that include Miss Wyatt?
It does, Your Honor.
When did she start working for you?
She started working for me in February of 2021 as a receptionist. I hired her as a receptionist.
Okay. Not an esthetician?
No, Your Honor.
Okay. Were you going to school at the time?
I was not hired in February. I didn't get my license until March of 2021.
What the plaintiff says is you were hired in February. She probably has documents to work as a receptionist.
I was not hired. I didn't even have my license then.
Did you have any proof that she started in February?
Your Honor, I have proof that she...
Was she on your payroll?
She was on my payroll.
Okay, so that
what we have document of in that is that she started brand new as a receptionist. Maybe it was in March of 21.
Okay.
I have my first paycheck stub.
I'd like to see it.
Okay.
This is a pay stub from April.
Yes.
Oh, okay.
Okay. This is your claim. Your claim is that when Miss Wyatt came to work for you, subsequently as the anesthetician, which she was, because she counted her among your 6 employees in 2021, that she had signed a contract which provided for certain restrictions should she leave. You don't have that contract.
I cannot find it. It was supposed
Okay.
to be.
You don't have that contract.
Nope.
Miss Wyatt, when you went to work for the plaintiff, do you recall signing a document?
I do recall signing documents stating like what my job title was and like the documents that would go towards what we went over and things like that for training purposes.
Okay.
Your Honor, I have non-solicitation, non-disclosure agreement documents of employees. There's 4.
Okay. Is this an employee of yours?
No, it is not, Your Honor.
Ever? Was ever?
Never been an employee.
Were either one of those 2 people employees, former employees?
Tabitha Brown was.
Was this a former employee of yours?
Tabitha Brown was a former employee.
At approximately the same time?
She was an employee of mine for 5 years up until April 17th, Your Honor.
Did she voluntarily leave or did you?
She voluntarily left.
Okay. Did she voluntarily leave to go to work with the defendant?
I did not know that until the day defendant left.
But ultimately you determined that she did?
Sure did.
Okay. She was with you for 5 years?
Sure. Yes.
I assume that if you have a business and you don't have this contract, which you allege if you could produce, had a specific non-compete clause in it, but you don't have it. She remembers signing something, but she doesn't remember exactly what it was. Can you stand up? Tell me your name.
Tabitha Brown.
Miss Brown, did you sign a contract when you went to work for the plaintiff?
Yes, I didn't remember that I did.
You did?
Yes.
But you did?
Yes.
Okay. Do you have a copy of her?
I sure do. And
just a second.
Okay.
Do you have a copy of it?
I don't.
No. But you have a copy of what she signed?
Yes.
I'd like to see it.
Your Honor.
No. Just
Okay.
let me see the copy. I'm trying to reconstruct something just to get some general parameters of this case. Tabitha Brown, March 22nd, 2022.
Yes.
Different.
Oh.
That is not the non-solicitation, non-disclosure agreement. That's a different agreement. Those are contracts she has signed.
Oh, well, you gave me 2 things. What is this?
One is her non-disclosure, non-solicitation, and also the second one is the role definition of an esthetician working for me.
Looking at the non-compete. Okay, this is pretty standard. Kevin, would you show this to Miss Brown? And I also want you to show it to Miss Wyatt. That clearly your signature.
Yes, ma'am.
Yes. And so that says within 1 year of your leaving Miss Landy's employment, you will not work in a related field within 7 miles from her current place of business.
Yes.
When you left her employment, did you go to work with Miss Wyatt?
We left to share. Yes.
The answer is either yes or no. So you did. You went to work with Miss Wyatt. And when you went with Miss Wyatt, that was sometime in 2022.
Yes, ma'am.
What month?
May of 2022.
Your Honor, that's incorrect.
Shh. I'm not needing your help.
Okay.
Angela Landy claims her former employee, Alishani Wyatt, stole clients and breached their employment agreement.
Now, does Miss Wyatt have a location, a shop, a store, a place of business, or does she operate out of her residence?
We share a space.
You share a space where?
At a salon studios in Valencia.
Have you calculated the distance between that space and Miss Landy's office?
I have, ma'am.
And how far is it?
3.4 miles.
Well, you're not allowed to do that, pursuant to the terms of your agreement.
Correct. I don't have a copy of that agreement, ma'am.
Well,
I have it now, but at the time I didn't. It's from 5 years ago, and I never received a copy of that. So it was.
I don't know whether you received a copy of it or not. It's your signature, and it's pretty standard fare.
Mm-hmm.
It's not that it's not standard fare. So, Miss Wyatt, what I have to do is sort of put together whether or not I believe that you, in fact, had the same document that you signed.
Correct.
And I believe that you did.
Okay.
Despite the fact she says that you probably took it when you left. I can't describe that conduct to her. But this is pretty standard fare, that within 1 year it's not too onerous, it's not within a 50-mile radius, it's a 7-mile radius. 3.5 miles is certainly well within that. You could have found someplace that was 8 miles away, and then we wouldn't be in this difficulty. But you didn't. Anyway, so you were in violation of your contract when you left and went to work and shared space with Miss Wyatt. Okay, but you're not suing her.
No, ma'am.
Why?
Because I know the case would be dismissed because of the lack of solicitation between clients and of a former employee.
Well, not necessarily. Those two stand alone.
Your Honor, if I may say, there was a small claims action against Tabitha, but because there was no evidence.
What do you mean there was no evidence?
I had no evidence, the way I have evidence today with Alishani, that Tabitha solicited clientele.
Okay. Now you can sit down.
Thank you.
So that small claims case was dismissed?
Yeah, I have nothing there, which I learned. I have nothing to stand on what I have to stand on today.
Well, what you had to stand on, Miss Landry, which I don't understand, you had a non-compete agreement with her. She's in violation of that agreement. That's all you need. And she violated this agreement. She went to work within 7 miles of your place of business. So I don't understand that. In this case, you don't have a physical signed contract. I have to reconstruct whether I believe that there was one. So I don't see why you think that you have all documentation.
I don't have documentation.
That's what I'm saying.
Due to the fact that I believe she stole the information out of my filing cabinet.
I don't know whether she did or not. Right now, you say it's a lost document. You can't find it.
Correct.
Okay. And the defendant acknowledges, and it's usually custom and practice in the business, to sign a non-compete when you have that kind of service industry. Right. And I'm prepared to accept judicial notice of the fact that when you go to work for a beauty salon or a hair salon or a spa, you develop a clientele within the spa. You can't open up a store next door and steal the clients. Most people have people sign this, and you did, and you had it done 5 years ago. So Ms. Brown is in violation of this contract.
That is correct.
Why somebody dismissed that, I don't know. I have no idea. Okay. So now you're going to demonstrate to me that Miss Wyatt solicited clients of yours.
Yes,
show me.
Okay. In July of 2021, Alishani was trained to be an esthetician.
Let's not go back to ground zero. I'm not interested. I am assuming for the purposes of this hearing that she signed a non-compete clause, just as Ms. Brown did. So let's start from there, and I asked you a very simple question. I said, what proof do you have that she solicited clients when she left?
Your Honor, my solicitation is here.
Fine, I'd like to take a look at it.
And my witness, Kennedy, is here as well.
Well, let's go to Miss Kennedy. Was Miss Kennedy a client of yours?
Yes, Your Honor.
Would you stand up, please? Your first name?
Kennedy. Kennedy.
Last name?
Johnson.
Ms. Johnson, how long had you been a client of Miss Landy's spa?
I want to say about 2019, Your Honor. I was there before the pandemic and was there for a while before it shut down due to COVID.
Were you there after it reopened?
Yes.
COVID. What kind of work do you have done there?
I get sugared, which is using sugar, lemon, and I believe it's honey and water, and you mix it together and it takes hair off of you.
And who did that for you?
I went through many of the clientele and the employees at Angela's shop at the time. So there were several people that, Alicia was one of them, as well as Tabitha.
How many times did the defendant do the waxing? Sugaring.
I want to say at least 5 times.
Do you recall when she left Miss Landry's?
I do not remember the date. However, I do remember getting a call from her company. I got a call saying...
From Miss Landry's company?
Yes.
Yes.
Your Honor, it's Landy.
Landy.
Yes, from Miss Landy's company. They had called me on my cell phone and told me that she was no longer there. And they had told me she was no longer there.
You can't tell me what somebody from her shop told you. That's hearsay. I want to know about the solicitation. If there was.
Yes. So one point while Alicia, the defendant, was there.
Sorry. Do you understand?
Yes. While the defendant was there, I had gotten sugared on my face. It was a small patch test. And after she had texted me, gave me her personal number, and told me if I had any reaction to text her and let her know. After I texted her, I had...
And this was while she was working for the plaintiff?
Yes, that is correct.
Go ahead.
And as a while, I started having a small reaction, and I had texted her and sent her a picture of my face and told her that I was starting to have a small reaction. I did not receive anything back for a little bit, and then I want to say around April, late March.
Well, when did you text her?
This text for the face patch was earlier, I want to say early March, maybe February.
Do you have the text?
I believe she gave it to you.
The third one, Your Honor.
What date did Miss Wyatt leave your employ?
April 22nd is when I got her immediate resignation.
April 22nd,
2022.
And is this what you're referring to? Hey, Kennedy, I forgot to tell you, if you wanted to book with me again, I could put you in my books. I'll be in Valencia.
That's correct.
And is Valencia where your shop is?
3.2 miles away, Your Honor.
No, answer my question. I have a question. Is Valencia where your shop is?
No.
That's my question. Why don't you just answer my question?
Angela Landy has accused her former employee, Alishani Wyatt, of taking her clients and breaking their agreement.
So Valencia is not where your shop is. Valencia is where your place of business is.
Yes, Your Honor.
Okay. So you left on the 22nd, is that correct?
That's correct.
On the 20th, 2 days before, you tell Miss Kennedy, because I assume that this was a planned move of yours, that she could reach you again at your new place of business in Valencia.
Yes, Your Honor.
Okay, well, you're not allowed to do that.
During the services, it's a very intimate service, so you start to gain a relationship with these clients. And through that time, I felt like I had gained a relationship. It wasn't just a client with Kennedy. So
You met her
Yes.
through the plaintiff.
Yes, Your Honor.
You started to work on her through the plaintiff.
Yes, Your Honor.
She had other people work on her other than you.
Yes.
She may have liked you better than the other people. That doesn't diminish the fact that you knew that you weren't supposed to solicit clients. You knew that. I believe that you knew that.
Yes.
Because that's standard fare. So your excuse is you thought you developed a personal relationship with her.
Correct, Your Honor.
How many other people did you develop a personal relationship with?
Majority of the clients that I had who were returning clients of mine, I felt like I had built personal relationships with.
If you're potchking around with somebody's face or scrubbing their body or giving them a scrub to get hair off on every part of the body, then you develop an intimate relationship with
Correct.
somebody. Now, your first name is Kennedy?
Yes.
Kennedy, did you ever go out to dinner with Miss Wyatt?
No, I did not.
She ever invite you to her house?
No, she did not.
Was the only time you ever saw Miss Wyatt while you were having a service?
That is correct.
You see, that's not an intimate relationship. That's just stealing clients, Miss Wyatt.
Okay.
So my question to you is, you're seeking damages, okay? Did you seek injunctive relief?
No, Your Honor.
Why not?
I didn't know about injunctive relief. In addition, because of the staff leaving, because of solicitation, admitted solicitation by Alishani to my attorney, and I have a sworn affidavit for that. Because of that, I ordered them a cease and desist, and they ignored the cease and desist. Alishani told my attorney that she did not
No, you can't tell,
solicit
jump up. You
hearsay.
can't tell me what she told your attorney. Do you understand?
Even if I have an affidavit?
Is your attorney in the military?
No, I just have a notarized affidavit.
From whom?
My
From
attorney.
Her? No, I don't take affidavits from attorneys. Okay. It's ridiculous. Are you still in operation, Miss Wyatt?
Yes, Your Honor.
How many people work for, with, or to you?
It's just me. I have my own personal LLC, and she has her own personal LLC, so none of our money is combined.
Miss Wyatt, how many of your former clients from Miss Landy's business followed you?
I would say a good portion. I don't have an exact number.
Yes.
Here you go.
Now, just tell me.
I would say at least.
No.
No, I'm sorry.
I don't want you to say I would say at least. I assume you have names, people.
I have names and people here.
How many of your clients
20.
went to Miss Wyatt?
20.
Not was solicited. Follow me very carefully. Not solicited by her, but actually left your business to go with her.
Actually left my business to go with her.
20.
Yes, Your Honor.
I'd like to see. Does that sound right, Miss Wyatt?
Yes, Your Honor.
Then I don't have to see. She says that that's about right.
Your Honor, I would also like to add that after I left, she did send out a mass text allowing all of the clients who had ever seen me to be aware that I was no longer there. So that also allowed more clients to reach out to me in different aspects.
No, my dear, you made the mistake.
Okay.
You made the mistake by opening up an office within a 7-mile radius, which you can't do.
Okay.
You solicited her clients. I thought maybe just 1 or 2, but 20, that's a lot of clients. 20 recurring clients is a lot of clients. Miss Landy's request in her small claims case is the maximum of the jurisdiction, which is $10,000. And I think that she deserves every penny of that.
Okay.
Because what you did was wrong and a breach of your contract with her. Judgment for the plaintiff in the amount of $10,000.
Thank you, Your Honor.
This court is adjourned.
And I have to tell you something, that's ongoing.
Okay.
Just so that you're aware.
I felt like the work environment was very unstable.
I have so many people to testify, including employees, that it's not a hostile work environment.
And I was constantly anxious there.
I was doing so much to improve the quality of the business by changing policies and procedures.
I had to do what was best for me and my family. I'm a single mom, so
hiring a business coach, working with an HR team.
Let the better business win, I guess.
The better business has won.
I was a little bit confused. Maybe you can shed some light on it for me. Why the plaintiff wouldn't sue for injunctive relief, because injunctive relief is suing not so much for damages, but to get someone to stop doing something. So in this case, it seemed to me that the proper ask, per se, would be injunctive relief to stop the defendant from operating her business in violation of her contract. But she didn't do that. She sued for damages instead. And I just think that this same problem could keep happening, that I think it's a good lesson for people to educate themselves or hire a lawyer to find the proper relief. Because what's to say that this is going to stop today? I'm sure she'll keep seeing the 20 clients.
Well, she's going to keep seeing the 20 clients. This judgment today was more compensatory than punitive, because if she had taken one client with her, well, she's in violation of the contract, and some token violation would have been appropriate. But she took 20 clients with her.
I got the feeling from you that you weren't exactly in line with the $10,000 number until you heard about
I heard
20
the 20
clients.
I mean, that's really
whole business,
some
really.
sort of chutzpah to knowing, and I believe she absolutely knew, she's a smart cookie, knowing that you had a non-compete, because her friend, who she also took with her, had the same documents signed in 2017. So, and she's clearly a businesswoman, so that would be a consistent practice of hers. I don't know who took the contract out of the file cabinet. It's for another day. I reconstructed it. I actually don't know why she wouldn't sue for injunctive relief as well as punitive damages. It would have been an option for her.
Smoody are suing their former son-in-law, Dalton McDonald, for unpaid loans.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2082, Smoody versus McDonald.
Thank you.
You're welcome.
Mr. and Mrs. Smoody, the defendant used to be married to your daughter.
Yes, Your Honor.
And according to what I've read, they were married for about 5 years.
Yes.
The thrust of your claim is that he owes for a couple of things, for rent and the balance of a truck. That's your lawsuit against him. I'd like to know, do you know the date of their marriage?
3/16/2011.
And your ex-wife's first name?
Jacqueline.
And when did you and your former wife separate?
In 2020.
And you had 2 children. How old are they now?
They are 5 and 8.
And who has custody of the children?
Dalton has physical, and they have joint custody.
Just a second. So he has custody of the 2 younger children?
Yes.
That's a yes. How long have you had custody of the 2 children?
Since July of last year.
At some point during the marriage, there was a truck purchased.
Yes.
Who purchased the truck?
Dalton purchased the truck. I co-signed for it.
And when was it purchased? Month and year?
June of 2017.
Was that the only car that they had?
Yes.
So that was a family car.
Yes.
And in 2017, was your daughter working?
Yes.
So both parents worked. And both parents, I assume, pooled their money and I assume made car payments.
Yes, Your Honor.
Yes.
Is that correct? Both. And then they separated in 2020, and at that time, the children came to live with you.
Correct.
And you took the truck.
Yes.
By agreement with your now ex-wife.
Yes.
in 2020 who made the car payments.
My husband did.
Is that correct?
Yes. I made all of the car payments on that vehicle, all of them, from the time it was purchased until we paid it off.
Okay, so what you're telling me is from 2017 you made all the car payments.
That's correct.
Did your daughter and son-in-law make any of those payments?
Not directly, but they paid toward the balance of the money that they were.
You paid for the truck.
That's correct.
Since 2017, since they
correct.
were married,
Yes.
with no reimbursement.
I took payments out of my daughter's check.
Just be very, very careful with me, sir.
Yeah.
I want you to be very careful with me. I read that, what we call in Yiddish, Bubameises in here, that you took money out of your daughter's check. Bubameises, it means grandma's tale. It means it's not true. It means it doesn't sound right to me. I read it in here. Don't try to repeat it here because that won't be good for you. Okay, I'm going to believe you if you show me copies of her checks that you made to her with withdrawals from money she owed you. That's all I want to see. Do you have that?
I do not.
Not, of course not. Now, he has the truck, and this was clearly either a gift or a marital debt. Either one of those two things. It's either a gift or a marital debt. It was a family car that was used by your daughter, her husband, the grandchildren, with, according to you, no reimbursement, according to you, except this ridiculous reimbursement from your daughter's check, which I don't believe, so I'm not even going into it, with no reimbursement 2017, 2018, 2019, 2020. And when your daughter and the defendant separated in 2020, according to him and according to you, he took the truck and the children. And that was with her consent or not?
Yes, it was.
With her consent. Is that so far right? That's what you're telling me.
It's accurate.
Right. Did you intervene in the divorce proceeding and say that there is money owed, marital debt owed, and part of the marital debt is this loan on the truck?
No.
No. The answer is no, you did not. It would also be fair to say that you don't know how much, according to you, she paid for the truck.
I do, Your Honor. I have that ledger that I have. I would go to her each week and say, Jacqueline, how much can I take toward the loan? And that's how much I would take off each week.
All you have to do, sir, is show me. Otherwise, this is a whole bunch of nonsense.
Yeah.
It's a marital debt. You did not intervene in the divorce proceedings and say, listen, this is a debt that's still outstanding, whatever it is, $2,000, $3,000, $4,000. You didn't do that. Now, the only thing that you can say to me with regard to this truck business is if you had, had an agreement with the defendant in 2017 to pay the truck. And be very careful, because what you've told me is he didn't make any payments to you from 2017 ever.
He made some payments.
Just a second. Interesting. Show me where he made payments. Did you give him a receipt for payments?
No, this is a small town, and
It's not a small town, it's a family, sir. It's not a small...
I do have the ledger.
I'm not interested in the ledger you created. It's self-serving and therefore inadmissible and created for the purpose solely of this litigation and not created at the same time that the event took place. I might even cut you a little slack if you had a ledger, a book with entries in it at different times from 2017 in different ink, with a day, how much was paid back on the loan. I guarantee you do not have that. You have a very nice piece of white paper that you created for me. Is that correct? That is correct.
That is accurate.
Okay, so I'm not interested in your ledger. That's not a ledger. That's a document prepared for the purposes of litigation. So I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck.
Claim their former son-in-law, Dalton McDonald, owes for unpaid loans.
Now, I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck.
That was from the very beginning because I was paying all their bills.
Just a second. I don't care whether you were paying their bills. I understand you were paying all their bills because they came to live with you for a brief period of time because they were evicted for whatever reason. And that was sometime in 2016. Okay. So I understand that you were paying their bills. Sometimes that's what parents do. They pay their bills.
We were paying their bills because they had no checking account.
That doesn't matter to me. I want to know your conversations with, where did it take place? Because you're not suing your daughter, you're suing him.
The conversation was when we rented the farm for them, which I know is not with the truck, but the landlord would not let them rent from them because they had terrible credit.
We'll get to the rent later. Stick with the truck. Don't talk to him when I'm asking him questions.
Well, the truck was the same thing. We put that on the ledger then, or on the running total, and they agreed. They both agreed that they were going to pay us off.
Okay.
He came over on Labor Day weekend, and I showed him the ledger, which he saw all the time.
No. Don't tell me what he saw. Don't tell me what he saw. If what you're saying is you showed him the ledger when he came over with the boys,
yes,
and he was going back to Minnesota.
Right.
And he brought the boys to see you to say goodbye?
Correct.
Okay, so far, it's very nice. You have a reasonable relationship with him, and certainly your daughter was clearly overwhelmed because courts do not usually split up children, so they must have felt that the children's best interest would be served if they remained with their father. Clearly what happened, the father came over to you to let you say goodbye to the children, and when he came over to let you say goodbye to the children, let me understand what you're saying to me. What you said to him was, not thank you for taking over this responsibility. Your daughter had more children than she could take care of, physically or financially, right? Clearly.
Yes.
Clearly. So what you want me to believe that two nice people who took in their daughter with her 2 kids and a husband and bought a truck and made arrangements for them to have some place to live, that these two nice people, when he came over, because your daughter couldn't take care of her children, and he brought them to say goodbye, you said, it's very nice. I want you to take a look at this ledger and see how much money you owe me. That's what you're asking me to believe, right? I'm going to let you live with that fantasy that I believe that.
And so I did give him the balance of what he owed me on the rent.
No.
And on the truck.
Nice.
And
he
he looked me in the eye, he shook my hand and said, Jerry, I promise I'm not going to screw you on this. I'm going to make those payments.
Make payments for what?
On the rent and on the truck.
Okay. Did you have that conversation with him?
No, I did not, Your Honor. The conversation was when I came up there the last time, Jerry was trying to sell his fishing boat, so I posted it on Facebook, and I sold it for him.
In what month and year?
That would have been September of 2020. After selling the boat, he gave me $1,200 for helping him.
How much did he sell the boat for?
It was $4,700.
So that was after you'd already moved?
Correct.
With the children?
Yep.
Okay. He helped you sell the boat for $4,700? Just answer my question.
No.
Did you give him $1,200?
No. He bought that boat from me a year prior to that. He had it.
So they bought this boat from you?
Accurate.
When?
That would have been in the spring of 2019.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know, I'm not buying your whole story. I'm not buying your whole story because what
Your Honor, I'm telling you the honest to God truth.
No, I don't think so. I don't think that I would have sold people who had no credit, who couldn't buy themselves a truck. So you had to co-sign for the only means of transportation that they had, who couldn't pay for their rent, who couldn't pay their bills because of their bad credit. I don't believe this whole scenario about selling them a leisure boat for $2,500. Is mind-boggling that you would think that an intelligent person like me would accept that. Okay, forget the truck. You have the truck now.
Yes.
Okay. You haven't finished your story with me, so you sold the boat, and he gave you $1,200.
Correct. I gave him the $1,200 back, which made us even on the truck payment, and he gave me the title. Tina signed it, and then I brought it back to Minnesota and put it in my name.
Okay. Who signed it?
Tina signed it.
My name was on it as well.
Your name?
Yes.
As joint owners with him?
Yep.
Co-signer.
Oh, interesting. In what month did Mrs. Smoody?
Yes.
Sign over the car to you?
The same day that I gave Jerry the $1,200, that would have been in September.
Now, do you remember the $1,200?
No, it was $1,000 that he paid toward the loan when I sold the boat for him. Okay. And it was his boat that I sold for him.
Okay. You did not create this as a marital debt. It absolutely was a marital debt. So I'm dismissing that portion of your claim that deals with the truck. Now, let's deal with the rent. The rent that you're talking about was rent in what property?
The farmhouse that they rented.
From when to when?
2016, November 2020.
And over the years that they lived there as a couple.
Yes.
The rent was paid to a landlord.
Correct.
By you.
Yes.
Is that right?
Correct.
And they, your daughter and her husband, would give you cash, checks, or whatever to cover the rent.
Yep.
Yes.
And how much did they give you to cover the rent?
When we started out, rent was $800, and later on he raised it to $900. We never made it a set amount each week. They gave us what they could. And we've done this before in the past, and they've always paid us back.
Well, then you should have sued them and listed all of this as a marital debt in the process of their divorce. So it could all have been...
We're handling Jacqueline in another way.
You what?
We're handling Jacqueline alone.
I don't understand what that means.
Well, you're saying it was marital.
Just a second. Does that mean that you've already served your daughter with a summons?
Not yet, no.
Of course not. Of course not. And you did know when they were divorcing. Yeah. You did know when they were divorcing. I'm not buying anything of this lawsuit, most of which, at least the rent part, is totally stale. I'm just curious, Mr. and Mrs. Smoody, somebody wants to answer this question for me. Mr. McDonald has custody of your two young grandsons, who I assume that you were close to because they lived with you in your house. And you seem like
live with us. The two boys came back to live with us.
From when to when?
December of 2021 until July of 2022. 6 months we had them.
Just a second, 2022. Was there a court proceeding?
No.
But then in July, they went back with their father.
That's accurate.
And they've been with their father since?
Yes.
Okay, so the boys lived with you for 6-7 months.
Right.
Was that an acrimonious transfer?
And Tina Smoody are accusing their former son-in-law, Dalton McDonald, of refusing to pay back loans.
Was that an acrimonious transfer, or was it something that you both...
What happened there was he called my husband to see if
No, don't tell me what he said to your husband.
Okay,
I will tell you then. He called me in December and asked me if I would please take the two boys. I told him, I will take them, Dalton, if you start making regular payments.
Oh, well, we're out of the money business now, sir. What you're saying is from 2017, when the children were in his custody, your daughter may have been there, but they were in joint custody, and then he maintained custody of the children, and during the time he maintained custody of the children, there was no question whatsoever that he was not paying you back money. He did not make any payments to you. Occasional here and there, we don't keep records. All of a sudden, now you have the boys with you. And then in July, he comes back and he takes the boys back. All I asked you was whether that was an acrimonious, which is an unpleasant, or a harmonious transfer of the children. Mr. Smoody was in July.
In July, it was acrimonious because at that point, he'd gotten a restraining order against me.
Against you?
Against me while we had the children. Because I sent him a letter saying that I wanted payment, and he went and got a restraining order against me because they took that as a threat.
I'd like to see the letter, please, Kevin. And this is what needs to happen moving forward.
That's correct.
You need to mail me $200 on the 1st of every month and $200 on the 15th, starting March 1st, 2022. If I do not get these payments on time, the following will happen, which is, you could say, I'm going to sue you, right? I'm going to sue you, but that's not what you say. You say, I will go to your boss and talk to them about garnishing your wages. Any employer that has gone through all the paperwork and red tape as I have will do anything to avoid it. So that's a threat. What you're saying is, I'm going to call your boss and tell him that I'm going to sue you, and then your boss is going to have to go through all the red tape of what it means to have a garnish on your salary. You have to go through accounting, and they have to deduct it. And no boss wants to do that, which is in effect say, so either you pay me or your boss is going to fire you. That's what you meant when you said, any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee. The only thing that
you can legally fire somebody.
Just a second. Whether you can legally fire them or not, that's what you were threatening. That's what that said. So we got an order of protection against you.
Correct.
And?
Then I didn't fight it because I didn't anticipate having any conversations or contact with him.
When you wrote this letter,
Yes.
you had the boys.
Yes.
Right. Not before.
No.
Not before. And he had had the boys for some time alone.
3 months.
He had had the boys for some time alone. Okay. Let's go back to my original question, which was, when the boys went back to their father, was it acrimonious or harmonious?
It was not good.
Well, so tell me your version of what happened.
The reason it was acrimonious is because he knew very well that once we got him, we put him on a strict schedule. 8 o'clock, brush your teeth, 8:15, pajamas, 8:30, bed.
Where was your daughter living at this time?
With us.
Yeah, just a second. If you're going to interrupt him because you want to get it out,
I'm sorry.
That's not going to be good for you.
She had a room at our house.
Just a second. So your daughter was living with you. So what you're telling me was your daughter was in the wind someplace.
Accurate.
Okay. You know, you had her for a long time. He only had her for 5 years. And I can understand the sadness if your daughter is in the wind and not being responsible, sir. But that doesn't mean he has to shoulder all the burden. Right now, he's shouldering all the burden of supporting the 2 children, which I assume you're doing. They're living with you. And so are you working?
Yes, I am.
And he's working. Your daughter is not.
She's working 2 jobs.
She always has.
If she's working 2 jobs, why was she in a room?
She wasn't renting. She was living there free.
Okay. So now let's get back to this acrimonious transfer by the children back in July.
Dalton called me, or called the kids.
Okay, so he called the children.
After bedtime.
Okay.
Called my wife's phone 4 times. Ring, 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 ring. And she wouldn't answer because kids were in bed. And then he called my phone twice. The second time, I have an old flip phone. I flipped it, walked in, because now I hear the boys are awake. I let them talk to the boys. And then I took the phone back and I said some naughty things to him and hung it up.
What did you say naughty things to him for?
Because I was very angry at him. Can I use some swear words that I used when I told him?
No, I assume you used some terrible words.
Yeah,
but
I just told him, don't call me anymore.
Is there any reason that you discussed with your wife why she didn't answer the phone?
Because the boys were already in bed. He had done that before.
You already told me that you heard the boys, so you took the phone into his room.
After the phone calls, they woke up.
Is what you're telling me that the first time that he tried to talk to the boys, that you or your wife didn't answer the phone?
I think it probably happened once or twice prior,
Okay.
and then we told him, don't do it anymore.
Okay, fine.
And this
Fine.
time we were fed up.
Fine. So that's when he said, I'm coming to take the boys.
No.
Well, when did he say he was coming to take the boys?
Not until July. Jacqueline told us that Dalton was going to be taking the kids once they got out of school.
Okay, I'm going to take the pain out of this case, and I'm going to do it relatively quickly. I think, Mr. and Mrs. Smoody, that this lawsuit was very ill-advised. The defendant doesn't owe you any money. He doesn't owe you any money because if there was money owed, it was a marital debt, and it should have been taken up at the time of the divorce, listed as a marital debt, and then it could have been fixed by the judge who approved the divorce how much and by whom is owed money. You chose not to do that. It was only after a very acrimonious set of circumstances, roughly 5.5 years later, after this truck was purchased, that you chose to exercise any prerogatives with regard to a debt, except this letter, which threatens to go to his boss to get him fired if you don't stop making payments, and that was only after the 2 children came to live with you and were sort of overwhelmed. You have to understand, Mr. McDonald, who I think probably is trying, he's got the 2 boys. It got very complicated, but it's not a lawsuit, and I would make nice with him. He's got 2 children that you probably want to have some connection with, and this lawsuit certainly doesn't help that. Well, anyway, for all the reasons that I've stated, your lawsuit's dismissed. We're finished. Thank you.
This court is adjourned.
He owes us that money. He admitted he owed us the money.
I think the judge was absolutely correct.
He promised he was going to pay us the money back.
I don't owe Jerry any money.
Kids are irresponsible, have no sense of honor, duty, respect, responsibility, nothing.
It really should be a family thing, and maybe one day it can go back to it.
This was a great case that explains why a lot of cases in civil court have a statute of limitations before you can bring a certain kind of case, because here it was hard for us to understand why they would not have requested that money back earlier. So when you ask for it now, years down the line where so much has happened, court's not so likely to feed into that because you don't know what the real motivation is behind it.
I agree. I think it's really foolish of them, especially since their ex-son-in-law has total custody of these two little boys, for them not to maintain reasonable relationship with him.
It was a good showing, though, that if you do give money to your daughter, son, and their significant other, and they do get divorced, you should follow that divorce proceeding. So if you do have a claim,
a legitimate
debt or claim, then
list it.
Jennifer Paramon is suing her former friend, Cardi Moran, for television damage caused during an argument.
Court come to order. All rise.
Have a seat, everyone.
Case 2144, Paramount versus Morgan.
Thank you.
You're welcome.
Ms. Paramount, you and the defendant had been friends.
Yes.
And according to what I read, there was a falling out, which you will tell me about briefly. Subsequently, and without too much time having passed, you decided to conduct an intervention, a drug intervention, with the defendant.
Yes.
And it is your claim that during that drug intervention, she damaged your television set, and you want her to pay for a new TV. That's what your case is about. The defendant has a cross complaint. She says she's missing some sort of a speaker. I don't know what that is. And for the emotional distress that she suffered as a result of this intervention. So I have a couple of questions, just preliminarily. How long have you known each other?
Over 20 years.
Friends?
Yes, best friends. Former best friends.
Former
now.
best friend. But there came a time, according to your complaint, that there was a falling out. And when was that?
That was in May of this year.
And what was the falling out about?
It was about our mutual friend and...
This gentleman?
Yes.
What about your mutual friend?
He was in the hospital, and we were all taking care of him. And she felt adamant to tell me that I need to do certain things for him. And I was letting her know that if he needs to tell me he needs my help, he can tell me.
Okay, there were several people looking after him while he was in the hospital, taking turns, is that right?
Yes.
And she was telling you things that you should be doing for him, and you said to her, if he wants me to do something, let him tell me, you don't direct me.
Correct.
Okay, tell me the next thing that happened that brings us to court today.
Well, after that, in May, I blocked her. We didn't speak.
Did you go to visit him?
Oh, yes.
Oh, yes. And did you?
Yes.
So you both did. Okay, so you blocked her in May. Then what's the next thing that happened?
Now we're in September, and this was...
And between May and September, you haven't seen her?
Haven't seen her.
Okay.
And now it's September. It's Labor Day weekend, and our friend Brandon wanted to mend our friendship back together. And it kind of did, because we've been friends for so long. We talked and kind of mended. Okay, so I unblocked her. And then on that Sunday, September 4th, she calls me at 7 o'clock in the morning, and I guess she still felt uneasy about, you know, us not talking for so long, that she demanded an apology from me.
She called you early in the morning demanding an apology for what?
For basically just, I was in the wrong of not listening to her about our friend.
Okay, and then what happened?
So I refused to give her an apology. I said, we can move past it, but I'm not apologizing, which she got upset again and hung up the phone on me. And after that, she basically called a family member of mine.
Not basically.
Sorry.
You say that she placed a call to a family member.
Yes.
Okay, and you can't tell me what that family member told you because that's hearsay. You
Correct.
understand that. Okay, so she called a family member, and that was on September 4th.
Yes.
Okay, the family member called you.
The family member actually...
Did what?
Actually lives with me. So they didn't call me.
Okay, well, you can tell me the relationship.
It's just family.
Okay, family member who lives with you, and?
So she was calling that family member, asking for...
You can't tell me what any of that was about.
I'm sorry. So after the conversation with the family member told me what she said. I know, I'm not saying the conversation.
Absolutely right.
So I told Brandon what she said, and we thought at the time, let's have an intervention.
Okay, now, so without giving any credibility to any out-of-court statements, I assume by the word intervention, you had a suspicion that the defendant was using drugs or alcohol.
Yes.
Before that, before September 4th, did you have any knowledge of ongoing substance abuse with your best friend?
Yes.
Since when?
For a very long time.
Okay. Did you ever discuss the drug use with her?
Yes.
Well, you can tell me what those discussions were like. What kind of drugs were you afraid she was using?
I prefer not to say.
Well, you can't not say. That's what this is all about. You wanted to have an intervention. You didn't want to have an intervention because she was having caramel-covered popcorn. There was a controlled substance, I assume, that you were afraid she was using.
Yes.
Which was what?
Cocaine.
Have you ever seen her using cocaine?
Yes.
Did you ever use cocaine with her?
Yes.
Between May and September, had you ever used cocaine with her?
No.
So it was before that?
Yes.
His name is Brandon?
Yes.
Had Brandon ever used cocaine with the two of you?
No.
Did you ever see Brandon use cocaine?
No.
Okay. So you, who had used cocaine with her, decided to have an intervention with Brandon?
Yes.
What do you do for a living?
I'm an inbound call agent. I sell tickets.
Okay. And what does Brandon do?
He's disabled.
And who was going to be at this intervention?
It was myself, Brandon, and another mutual friend.
Mutual friend. Now, this mutual friend, whose name I will not have you state, have you ever seen that mutual friend use any sort of controlled substance? Answer the question.
Yes.
Yes. So now you have two people who've used controlled substance, one who has not, to your knowledge, doing an intervention.
Correct.
Okay. And do you know what an intervention is?
Yes.
What is it?
It's basically a meeting of the minds of having a discussion with one person about an issue that...
And who's there?
Who's there?
Yeah.
Oh, I would say trusted people that I would feel that they were...
Sarah, I want you to look up the word intervention and read me the very, very simplistic definition of an intervention.
From the Mayo Clinic, an intervention is a carefully planned process that may be done by family and friends in consultation with a doctor or professional, such as a licensed alcohol and drug counselor, or directed by an intervention professional called an interventionalist.
Okay, so what you don't have is something, I assume, this conversation occurred on September 4th.
Correct.
Was it on that same day that you decided to have an intervention?
Yes.
Okay. So let's start with the word well-planned, not as a result of a conversation that you have with somebody. And it's a well-planned event done in conjunction with very often relatives or close family who have a concern that something is out of control, some abusive behavior that's related to either alcohol or other controlled substances, in conjunction with a licensed professional where everything is synchronized, but managed by a professional. Do you understand?
Yes, this was a bad plan.
There was no plan. It was a plan made because you were annoyed.
Jennifer Paramon claims her former friend, Cardi Moran, broke her television. Cardi is countersuing for emotional distress.
Now, you were annoyed at the conversation, so what you did was not really an intervention. What did you think was going to happen at the end of this intervention? What was supposed to happen to her? According to what I read, you called her, or someone called her, probably your family member, called her with regard to these drugs that she wanted to purchase. Is that what happened?
Yes.
And said, I have them come to the house.
Yes.
Okay, so that's not a giant leap. You have to put that together. So she calls your family member for some cocaine. You arrange for an intervention. Your family member calls her at your request and says, come to the house. So that's what happened.
Yes.
Okay, but she was lured to your apartment.
Yes. Yes, I was.
Yes.
By whom?
By us. By her.
What do you mean by us?
Myself.
Shut up.
Myself, Brandon, and another
Well,
mutual
who
friend.
called her and said, come over?
Who called her?
Yes.
We were already going out. She was already going out with Brandon.
Just a second. She was already going out with Brandon.
Yes. And she decided to come to where I live to come pick up these drugs. Because when she found out that basically the setup was for her to get her to my house. So I told my family member to tell her that we did have it.
Oh, just a second. That's what I said. So she was lured to your house.
Yes.
Where you were going to do what with her? What happened when you got to your house?
Basically just talk.
Not basically.
Sorry.
Not basically. You lure somebody to the house. She's come to the house now expecting, let us say, expecting to buy drugs or get drugs. She gets there and realizes that that's not going to happen, that there are other people that that's not going to happen. So tell me what happened when she walked in the house. That's what your case is.
Well, when she walked in the house, I immediately tried to give her a hug, and she was upset.
No, you immediately tried to give her a hug. What did you say?
I didn't say anything. I just opened arms, and she said, no, it's fake, backing away.
It's fake? What's
Yes.
fake?
My hug.
Okay, so she backed away.
Yes.
And
it just started off with...
No. Somebody had to say something to her. Somebody had to say this is an intervention. Somebody had to say why she was there. She eventually was going to say, where are the drugs? But you have to tell me what happened.
Yes, when she walked
in, you went to give her a hug, pushed you away. Then what? Come on, this was an intervention.
Yes. So we couldn't even get to the part of this is an intervention.
How could you get to an intervention? You don't know what an intervention is.
Well, we couldn't get to a part of let's talk. She immediately said she was being set up. This is a setup with arguments back and forth.
Well, what were the arguments back and forth?
The back and forth arguments.
She said, I'm being set up. Somebody said to her, this is an intervention.
We didn't get to that part.
Well, what is the setup that she was talking about?
I don't know why she said...
Well, it was a setup.
It was a setup. It was a setup.
Yeah, so I want to know what your end game was.
The end game was to have a conversation with her so we can resolve our issues of why does she need an apology from me? We have been friends for so long. Her getting to my house, yes, we did lie and say, yes, there was drugs at my house. But she already knew from how we're all there that there was no drugs. She was upset. She was irate. She was bringing up the argument that we had earlier in the morning.
So this wasn't an intervention for drugs or alcohol?
It was an intervention for drugs and alcohol.
Oh, okay. Then I'm asking you, not what happened, what was your end game?
The end game was to have a conversation with her about how much drugs she was doing because it changed her mood. It made her angry.
Well, did you have a program for her to go to? Did you have a program to take her to? Had you spoken to a professional? Had you done anything?
No.
Okay. And when she was there, according to you, she was in your house with 3 other people?
Myself and Brandon and another mutual friend.
So with 3 other people,
yes.
So she was there with 3 other adults.
Yes.
And she was lured there under false pretenses.
Yes.
And what she did, according to you, was pick up a chair and throw it at you, or threw it at a television set, breaking the television set.
She didn't throw it at me.
What did she do?
She threw it directly at my television.
Lucky she didn't throw it at you?
I wish she would have.
That's
exactly what she said.
Just a second. You're lucky. You can't do what you did. That's almost like kidnapping. If you're having a serious intervention, you have to sit down, have a working plan, what happened, have the right in your heart, have the right messaging. Your messaging was all wrong. Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, and they seek professional help in order to get that person professional help. But they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
It was
you
bad.
Can't do that.
It was bad. It was
very bad.
Yeah.
So you fix your own television set. Your case is dismissed.
But Your Honor, I have it all on video.
Did she break your TV?
Yes.
I'm going to look at the video. Your case is still going to be dismissed. I believe she broke your TV. Show me the video. I believe it.
And I also have
I believe that you're lucky that's all she did in order to get out of your apartment. Did she ultimately leave your apartment?
Forcefully,
yes.
I kicked her out.
So forcefully, you tricked her into coming in, and then you kicked her out?
Yes, after breaking my property.
Okay.
Dad, why are you like I
am I being recorded?
Just a second. I don't know why you're being recorded. In any event, yeah, as I said, your case is dismissed. Fix your own TV. You have a counterclaim.
Yes.
And your counterclaim, I don't know what this speaker is. What is a speaker?
A speaker, you connect your phone to Bluetooth and you hear music on it.
Okay, so what was it doing at her house?
Shh. We were supposed to be hanging out. So I was supposed to be hanging out with Brandon and another mutual friend. I didn't know we were gonna stay at Jennifer's house.
Okay, I just want to know what you brought the speaker?
Yeah, a speaker.
And you left it there.
I didn't leave it there. My things were scattered. When she was kicking me out, my things were scattered, getting kicked into the hallway.
Jennifer Paramon has accused her former friend, Cardi Moran, of breaking her television. Cardi claims Jennifer caused emotional distress after being tricked by Jennifer.
Okay. Did you look for the speaker?
Yeah, I looked everywhere in the hallway.
Do you have her speaker?
There was never a speaker.
Did you see a speaker?
No, I didn't.
Okay, there's no speaker. Now let's talk about your emotional situation. You got to this, I can't even call it intervention.
Trap.
Trap, that's a good word.
There you go.
That's a good word, thank you. And tell me what happened when you got there.
When I got there, I asked her family member to come downstairs.
Okay. Miss Moran, you walk in the door.
Yes.
And there's no question that you were tricked and that this was a trap.
Yes.
That's what it was.
I realized that maybe 1 minute. Okay.
That's what it was. Got in there, and it was an uneasy feeling. You realized that it was a trick to get you there. It was a trap. I want you to tell me what happened when you got inside.
Jennifer starts to walk up to me, like, with her arms open, real slow motion, like, Cardi, I'm sorry. You know, we should talk about this. We're friends. In that same tone. And I'm like, yo, really? You're being fake. I don't really want this. You know, I came here to get what I wanted, and let's go. But Brandon is getting all comfortable. He is disabled, so, you know, all right, fine. He's got to get comfortable. So we start arguing, me and Jennifer, we start arguing.
About what?
About the conversation that me and her had earlier. You know, she said that I should just get over what she said initially for me getting upset.
Okay, so the initial conversation didn't have anything to do with drugs?
We never talked about drugs. When I got to the house, I never had anything to do with them. I was talking to the family member, what I came to get. But once me and her start arguing, I tell Brandon, like, all right, can we go now? Like, are we done here? Like, let's leave. I want to go.
So what happened? When you said to Brandon, let's go, I want to get out of here, what happened?
She squirts me with a water gun. She tells me, oh, I'm going to squirt you like I squirt the dogs.
Brandon, stand up. Your last name is?
Milner.
I want you to describe this water gun.
To be honest, Judge, I don't remember seeing no water gun.
It's in the video. If you listen to the video, she says it. I'm going to squirt you
Brandon,
like I squirt
before
the
I
dogs.
look at this again, you were there in the room.
Yes.
I'm going to give you one before I look at the video again. Whether you saw her squirt the water gun or not, did you see a water gun that day?
No, I didn't.
No, okay. So let's play this and let me hear what you're referring to.
Why are you like I squirt the dog? I said that. Are you serious?
Okay, Sarah, you have a much more keen sense of hearing than I do.
I'm going to squirt you like I squirt that dog.
Okay. She's got younger ears than I do. What?
I never squirted her with the
Whether you did or not, are you telling me that
said
Sarah
it.
heard? Okay,
said
so
it.
you did squirt.
But I
you
didn't
didn't say
squirt
it.
her.
I'm going to squirt you like I squirt the dog. Yeah. Okay, but that's not an intervention.
We were arguing at that point. It was already past the
That's because you lured her there.
intervention.
Because you did the wrong thing.
Yeah, it was a horrible plan. It was horrible.
Oh, yeah, they're absolutely right. And it caused a great deal of distress. I want to know how you got out of the apartment.
I was kicked out. I was pushed out. My things were thrown into the hallway.
At what point did that happen? Is that after?
Literally 3 seconds after.
After the TV was broken?
Yes.
You were pushed out the door?
Yes.
Well, that's some really good intervention. How long were you in the house?
A total 6 minutes, maybe.
Where did you go from there?
I got picked up and went home.
Got picked up by whom?
2 hours later by my sister-in-law.
Don't make anything up.
No.
Who picked you up?
My sister-in-law.
Okay.
And my daughter and her boyfriend.
In that 2-hour period,
Yes.
you must have waited somewhere for them.
Yes, I waited in her hallway.
Okay, so you waited. When they came to pick you up, was there any further conversation with her or Brandon? They just picked you up.
Well, between those 2 hours, there was conversations between my daughter and Brandon, my daughter and Jennifer. Everyone was talking.
Well, where was your daughter?
She was home.
So it was on the phone that they were talking?
Yes. And she was pleading with them to give me my stuff back so I could just leave.
The cross complaint or the countersuit is seeking $1,800. It's seeking $1,800 not only for the emotional distress that was caused to the defendant, but also for a speaker. They don't have a speaker. How much was the speaker so that I can deduct that?
It was $129.
Okay, so we're really talking about $1,700. Okay, and that's the amount that you want for your emotional distress.
Yes, Your Honor.
For that 6 minutes. I don't blame you. I think it's worth at least that. I think that when amateurs decide for all the wrong reasons to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out. Absolutely. You are holding her there. Yes, just a second. You brought her there under false pretenses. That's what you did. And you had somebody else there as well. And according to you, you wrote it was an intervention. But it wasn't an intervention. It was whether you wanted to.
For a 20-year relationship, I made an intervention, maybe a wrong
Well,
word.
it was
but
it was a very,
conversation.
very wrong word, and you don't trick somebody to come to your house with something else in mind, even if it's to buy drugs. So I'm awarding you $1,700 on the counterclaim for your emotional distress. Your claim for the broken TV is dismissed. We're done.
This court is adjourned.
I have no thoughts.
I'm happy with her decision, but it's bittersweet because these are my friends.
Just have a conversation about certain situations we were having.
Her intention, I don't think it was to make me stop doing what they all do anyway.
I didn't keep her, that's the thing. She walked in freely, walked out.
That's the betrayal.
Yeah, this is over.
It's just time to go separate ways. You know, I lived and I learned. Those are the people that I grew up with. You know, those turn-up days are over anyway, so.
I think this whole situation was a perfect example of what my dad calls lack of two-step thinking.
Okay.
So we can already agree the intentions were not great. They were just maybe potentially rekindling a friendship, and that's not exactly the person you want leading your intervention, if that's what they wanted to call it. And also, what was your plan? If it went the way that the plaintiff at least claims she was intending it, was to get her friend help, say that the defendant broke down and cried and admitted to having a problem and really wanting help. Where was the help? There was no help.
That's true.
So I agreed with you that the plaintiff deserved any amount of damage that happened from having such a lack of a plan.
It was a lack of a plan. She lured her there.
Yeah, I mean, just a messed up situation all in all. And you really have to be coming from the right place to do something like that. And I think neither of them were even close to that sort of healthy place.
Neither the witness nor the plaintiff.
Jeremy DeTorres is suing his former employer, Chad Young, for unpaid wages and filing a false restraining order.
Court come to order. All rise.
Have a seat, please.
Case 2140, DeTorres versus Young.
Thank you.
You're welcome.
Mr. DeTorres, according to your complaint, you did some work for the defendant as a plumber. Didn't work out, and he terminated you, and he owes you some wages.
Yes, ma'am.
The defendant says that while your work in the beginning was okay, you were never an employee of his. You're an independent contractor. That's the way he sets it up, and he's going to explain that to me. That he paid you your wages, even though the last job that you did cost him an awful lot to repair. He was not happy with the quality of work that you did, and his counterclaim is for vandalism, something that happened with his truck, work hours lost due to your incompetence. That I'm not going to hear, sir. You know, you make a choice with an employee, and if it turns out to be something that is less than satisfactory, then you let them go. But the one who I assume suffered from what you call lack of quality work that he performed was the person that you were working for. Was that a private residence that he was doing work in?
Yes. Yeah, a bunch of
that's
private residents.
Yeah, that's the person who suffered.
Yes.
Yeah, sure. Okay, so we're going to make this as easy as possible. From what days to what days did you work?
I worked for Chad from June 13th to August 3rd.
And how much were you supposed to be paid?
For those 3 days, $840.
And that's for 3 days' work.
Yes, ma'am.
Did you say June 13th
Yes, ma'am.
to August 3rd?
Correct.
Well, that's more than 3 days.
No, his wage he owes me from August 1st to August 3rd is what he did not pay me for.
Okay, and where did you work during those days?
Multiple residents.
Okay, do you have any sort of a call log from him?
I do. It's right
Okay.
here in my
Do you
short.
dispute that he worked from August 1st, 2nd, and 3rd?
Yes.
You dispute that
There was one day he actually did one of my jobs for a couple hours that day.
Doesn't matter. He has a log.
Half a day for one day.
Did you pay him for that half day?
I did not because the job was done incorrectly multiple times.
But he did that job. Okay, now, do you have a log?
As in?
It's some sort of a work log. You have a business. You have people who are general contractors. You get a call. You don't have a payroll because you pay these people independently. Do you pay them in cash or check?
Both.
Well, how did you pay him?
Sometimes it was through a cashier's check and sometimes it was cash.
Okay, but never through a company check where you deducted Social Security.
No, because I 1099 all my employees, so they're all self-employed, so they have to do all that on their own.
I do understand. I mean, you're not the inventor of this whole system, sir, of paying in cash. Okay. Are you one of those independent contractors?
Yes, ma'am.
Stand up. How long have you been an independent contractor? with him?
I've been contracted with Chad since July 5th.
Of what year?
This year, 2022.
Oh, so short term.
Yes, ma'am.
Does he pay you in check or cash?
Uh,
No, look at me.
check it first, and then later on it became through Venmo, and then it's gone back to check now.
What kind of check?
Cashier's check.
Just a straight cashier's check with nothing taken out.
No, ma'am.
No, I go to my bank to get all that.
What?
I go to my bank to get the cashier's checks, and sometimes I Venmo him the payment too, just to pay.
I understand, but sir, you're not the first person who I know who pays their people in cash and says that you're independent contractors. You're independent contractors. I don't want to know about it. What name do you use for the cashier's checks?
My personal name.
Is this the first time you've worked for him?
Yes.
Okay, let me see what you have for August 1st, 2nd, and 3rd. Where did you work? Come on.
There were multiple residents, ma'am.
Well, you have to tell me so that he can answer. He said that
They
you
were
worked half a day that he didn't pay you for.
Yes, ma'am.
So let's say that's a full day. So that's $200.
Okay. See, he would email it on his work phone, and I'd follow the addresses there.
Well, then you would have
write
it on
down
your
my
phone.
short notes
Just
on
a
this.
second. Then you would have it on your phone.
It was his company phone. He took it back when he came to my house unannounced and told me that I was fired. Redeemed his truck. Got my tools out of his vehicle.
Okay, just a second. Do you have your phone?
I do. I have my personal one that I.
What about the phone that you took from him?
No, that one's actually broke, so it's been with Mo for the past week.
Let me see the notes that you have that you took.
Yes, ma'am.
Fascinating.
It's my shorthand, ma'am.
How do I know what dates these are for?
It was all on his phone, ma'am.
Well, that's not him to have to prove, sir.
I wasn't able to prove anything when he took his phone back. I just had that's the notes when I was employed for him as I wrote down.
It's not helpful to me.
Yes, ma'am.
So far, the only thing that he's acknowledged is that he owes you a day's wages.
Yes, ma'am.
Which is $210. The other part of your complaint is a false restraining order against you.
Yes, ma'am.
Did you file a restraining order against
I did.
him? Do you have a copy of what you wrote in your restraining order?
I do.
I'd like to see it.
So what got me that restraining order is he called, made threats, and made
Was
threats.
this after you fired him?
It was.
Okay, so after you fired him, he called you.
Made threats.
Well, what did he say when he called you?
Just basically talking about I'm gonna come to your house and everything.
He wanted money.
I guess, yeah.
He said, you didn't pay me.
Yeah.
Okay. You say you got a text message and voicemail from Jeremy threatening to come to my place of residence.
Yes.
Can I hear it?
Yeah. Do you want me to play it, or do you want to look at it?
I want to look at it.
Okay.
So, Mr. Torres, did you, after he fired you and came to your residence, took your house, did you call him threatening to come to his house?
I did.
You did?
With the police. It says it on these text messages, ma'am.
Okay. I'm going to take his phone and those text messages.
There's more text. That's just the one where he said he'd send me my money.
That's the voicemail if you want me to play it for you. Sometimes the transcription doesn't work.
Yeah.
You want me to play it?
Just.
Hey, bro. I definitely worked more than 9 hours for the last week that I worked for you. I'll be contacting my... Play with me. I'll show up at your house.
Yeah, that's a threat.
With the police.
Just a second. That's a threat.
Yes, ma'am.
Okay.
I've had more.
That's a threat.
I
Just
had
a
more
s-
incidents before that as well.
May I say something, ma'am? He accused me of going into his gated community, slashing tires on his work vehicle. I stated that I was going to come to his house after, if you read my text, I said to him, hey, bro, I think I misunderstood your text message. If I did, my bad. If not, I'll show up at your house with the police. I never went to his house. I waited to see if he'd be the big man and just send me my money like he said he would.
I listened to the message, sir.
Yes, ma'am.
The message sounded threatening.
Did you read the rest of them?
I don't care. That message sounded threatening.
Eddie Torres claims his former employer, Chad Young, owes for unpaid wages and filing a false restraining order.
Okay, that message alone, if he felt threatened because you were going to come to his house, and you not only said you were going to come to his house, but you used an expletive before you
And
did
he
that,
did-
which sounded threatening. This may be more benign, but that phone message was sufficient for him to file for a protective order against you.
Okay, why didn't he show up at the protective custody order?
I don't answer your questions.
No,
you don't
you're-
necessarily.
Absolutely.
Some people don't pursue it because once it's done, it's done.
It wasn't done.
And once it's
This
done,
is
did you
the dismissal
afterwards-
right here.
a-
Dismissal for the
No,
injunction.
didn't show up. I understand he didn't show up, sir.
Yes, ma'am.
But I'm saying to you, I listened to your text message,
ma'am.
and he had an absolute right to
Can
see.
you see where he threatened me as well with all these back and forth texts and calling each other? Because it's in the text
You're
messages.
suing him for money owed for wages and filing a false restraining order.
Okay.
You've proven that you worked an additional day for which he didn't pay you, which is $210. He has a counterclaim. He says that you vandalized the tires on his car. The rest of it, I'm not dealing with, sir. You picked this employee. You don't then sue the employee if you don't like the job that they do. You fire them and you get somebody else to do the job. But you can't sue him because did the person who you did the job for sue you?
No, because I've got a really good reputation with my customers.
Because you fixed it. Because it wasn't done right.
Yeah.
Okay.
Even up to that last day I said he worked for me, that job I had to go back to 2 weeks ago that they couldn't close on the
Well,
house.
then next time you won't hire him. Maybe other people won't either. But I want you to tell me about the tires. I want you to tell me what proof do you have that he had anything to do with your tires? When were the tires slashed, flattened?
So the police report was done Friday when he made the threats.
Friday. What's the date?
I got the date right here. I think it was
August 5th.
Yeah, so August 5th is when he did it.
August 5th is when
The police report was made for the threats.
for the threat for the voicemail.
Yes.
Okay.
Okay, so it was the end of the day Friday, so court's closed for the weekend.
August 5th.
Yep. And then Monday, the 8th, I went outside to go to work. My tires were slashed in the end. At that point, I realized it was just over and done, and I need to go down and get a restraining order so people can't come onto my, my property.
Because
area.
you believed it was the plaintiff who was responsible. You believed you didn't have proof at the time.
Yes.
You didn't have proof.
Again, and even in my injunction, I knew all I needed was this police report to get the injunction, so I just put in my police report.
You're
that
not
my
talking
tires
about
were
an
flat.
injunction. You're talking about a restraining order.
Yeah, the restraining order. Yeah,
Okay.
so I
It
went
was
to file the
injunction.
restraining. So in my restraining order,
Mhm.
I put just my tires were flat. I did not put my tires were slashed at any point because I knew the police report was enough to get the restraining order.
Okay, your
so I didn't
tires
go
were
in
flat.
detail about my tires.
Okay, so in the police report, you have that your tires were flattened.
No, that wasn't on the police report because that didn't happen yet. The tire incident did not happen.
Okay.
That happened Friday. Monday morning, I went out in my vehicle to go to work. That's when I found them flat and slashed.
Did you file another police report?
That's when I went and filed the restraining order that day. And I have
Okay,
a
and in
copy
the
of that
application for a restraining order, you said?
that my tires were flat, and that was it.
Yes. Okay.
I didn't mention that they were slashed.
Correct.
So I don't know how he would
Got
know
it.
my tires were slashed. if I didn't mention it on my restraining order?
I don't know. That's an interesting question. Mr. DeTorres. Mr. DeTorres, stop your paper fluttering.
Okay.
What made you think that the defendant's tires were slashed rather than just the air let out of them?
Because I read this police report and it has a mark right here saying, or the file that he did.
Show me. And make a
It's
circle.
Right here, damaged property is what I read. He checked that I damaged his property because this is written against me.
Mr. DeTorres, do you understand my question, sir?
Yes, ma'am. I'm sorry. I'm nervous in the
Just a
flight.
second.
I
This
had no
has
sleep.
nothing to do with nerves,
You're
Mr.
right.
DeTorres.
Well, I had no sleep last night.
That has nothing to do with sleep.
As far as not being...
Just a second.
Yes, ma'am.
What I'm asking you, Mr. DeTorres, is where does it say here that his tires were slashed?
In my mind, somebody writing that against me, flattened tires, what else would it be? He lives in a gated community.
Well, that could
Where's
be...
the surveillance showing me that, that my leg injury, the way I walk, is very distinctive? Okay? If he's got proof that I slashed or flattened his tires, I said slashed. It's the same thing as flattened in my mind. That's the way I think. The way I read that, that's just how it came out of my mouth.
But you have to understand that that's not what this says.
Okay? It says that I damaged his
He
property.
said damaged his property, and you said slashed tires.
Okay.
Okay?
Yes, ma'am.
How much were the tires?
$450.
Let me see the receipt.
I do not have a receipt because I pay cash for my tires.
Well, that's too bad. You better stop paying cash, sir. You can pay cash for tires.
Yeah.
But when you buy tires with cash and you want to sue for them, you get a receipt.
Yeah.
From the people. And if you know you're coming to court, we're not talking about things that happened 2 years ago.
Yeah.
You were coming to court today.
I went back to the tire shop and he's like, we just, we always do cash for all your vehicles. And
Well, what's the
receipts, no
cash
nothing.
for all your vehicles? That means you get a receipt. All right, your counterclaim's dismissed because you have no proof of anything. On the complaint, sir, I'm awarding you $210, which is 1 day's pay. Thank you very much. This case is over.
This court is adjourned.
The work just wasn't up to the quality that he promised he was going to offer.
It is what it is.
That's just his nature. That's always been his nature.
The judgment is what the judgment is. She felt like I was only awarded a day's pay, and that's what she gave me.
Keep doing what I do. That's all I can do every day.
Well, Sarah Rose, that is the perfect example of you're supposed to have proof when you come to court.
Yep. Standard of proof exists for a reason.
I know that when I go someplace, and sometimes I pay cash.
Mm-hmm.
So even if you pay cash for something,
There's some
or Venmo,
record. Venmo
you're
is a good
supposed to
record.
get a receipt in the event that you want to use whatever you bought and use that fact that you purchased something in a subsequent lawsuit.
Yeah.
It's the same thing as sending a gift. If you send somebody a gift, you keep the receipt until you know that they got the gift.
Yeah.
Then you take it and you throw it away. It's just
It's good bookkeeping. It's good record keeping.
And he's a business guy.
Yeah.
He's a business guy. Didn't make sense to me, but clearly plaintiff is somebody who has a little trouble.
Yeah.
Case 2137, Wise versus Light. All parties, please step forward.
Caitlin Weiss is suing her ex-boyfriend, Cody Lipe, for unpaid loans.
Ms. Weiss, the defendant was a boyfriend of yours for a period of time.
Correct.
And you allege a couple of loans. One from 1.5 years ago, the balance of a $200 loan, he paid you back $100.
Yes.
Quite frankly, I'm not interested in what happened 1.5 years ago.
Caitlin Weiss claims her ex-boyfriend, Cody Lipe, is refusing to pay back loans she gave him during their relationship.
Okay, in March of this year, you allege that you gave him money. He was still your boyfriend in March of this year, is that right?
Yes.
Is that correct?
That is correct.
And in March of this year, he had gotten a car. What kind of car did you get?
It was a Buick Regal.
What year?
A 2004, I believe.
Where did you get it from?
I got it from a private seller.
How much did you pay for it?
$850.
Needed fixing.
Yes.
And you didn't have money for parts.
I did for the first round of parts.
But you didn't for the second?
After the first ones failed, I did not.
And how much did you need for parts?
That I don't remember.
Who bought them?
Miss Weiss did.
Did you buy them on a credit card?
I believe so, yes.
And you have no idea what you paid for those parts?
I don't remember.
But that would be in March of 2022.
It would have been in April.
Did you pay for the parts by credit card?
Yes, I paid between Cash App transactions that were transferred to Mr. Lipe through Cash App, which I have present here.
I'd like to see proof of them. What do they total?
They totaled up to $920.
Does that sound about right, Mr. Lippy?
That's about right.
Okay. And tell me about the discussion that you had with her when she paid for these parts.
There was a discussion of how I was going to pay her back.
And what did you tell her?
I did agree at that time.
And then what happened?
There were then later discussions as we were still in a relationship and I was in financial troubles that she told me not to worry about it.
This 920 was a loan in April of 2022. That's what you say. It was in April, not March.
Correct.
And then you say at some point she forgave that loan.
Right.
Tell me when that happened.
Shortly after the car got back together, which would have been in May. I was financially struggling.
Well, you weren't living together at the time?
No, she would periodically come over and
but you weren't living together at the time. So how would she find out that you were in financial trouble?
I mean, we were at that state in our relationship where she knew basically my financials all the time.
When did the two of you break up?
I believe that was in June.
So shortly after you say she forgave the loan.
That is correct.
Did you ever forgive this $920 loan?
No, I did not. Brennan Black was there the day that I had confronted Cody at a car meet and had offered him a short little payment of $790 where Cody said he would do it in payments.
Just a minute. You broke up in June.
Correct.
He says that you had a conversation before that, sometime in May, where you knew he was in financial difficulty. Did you ever have that conversation with him?
No, that is incorrect. I do have statements here to prove it as well.
I'd like to see them. So then you said he owed you $970. He had been giving you some money?
Yes, he had been giving me
It says, so that puts you at $670, okay? That's what you wrote.
Correct. He had been giving me money periodically throughout the beginning of the car parts.
Okay, but it says, so that puts you at $670, okay?
Yes, there's more transactions on the Cash Apps as well.
Oh, after that?
Yes, correct. Sorry.
No, sir. What you say is I need time to catch up. There's no forgiving here unless you have some.
It was a verbal conversation.
Well, what's in writing?
Right.
What's in writing is you saying to her, I need some time to catch up. I can make payments to you. All of that is in writing. But the thing that you don't have in writing is where she forgave the loan. Is that right? Yeah. $920. Judgment for the plaintiff. We're done here. Thank you.
This court is adjourned.
It is what it is.
I think it was fair. Mr. Lake did owe me money, and he got what he deserved.
Yes, she lent me the money, but at the same time, she was helping me out in a relationship, and she knew I was struggling.
He said he was going to pay me back and never followed through even after that.
There were discussions about her telling me not to worry about it.
Not to trust so much.
I'm never going to do it again.
Oh, that's going to be a contract.
She was very prepared.
Oh, she was to the point, knew exactly what she needed.
And she had all of her evidence.
Yep.
All
just the way we like it.
All lined up. It's unfortunate when a loan becomes a gift and a gift then becomes a loan when the romance is over. These writings are always so helpful, and these text messages really are making my life much easier.
And one thing that I mention a lot is with Cash App or Venmo, always state if you're paying someone money, don't just send the money, put in the subject line. They have a subject line on those for a reason, for this car part, for this tow, for this XYZ, the other. So I always, when using Venmo or Cash App or something like that in an online transfer system, I'll send the money, and then in the transaction, you can put whatever you want in the memo line of Venmo. So housekeeping for me, I'll pay through that. Or other things, I list housekeeping for, and I put the date and the hours. So I at least have a record of who I'm paying electronically.
If you buy food,
or if I give someone money for dinner for half my meal, I say for my dinner on XYZ date.
And then you can get a printout.
Organized. Exactly.
And then you can, like a bank account?
Yep.
Interesting. I didn't know that.
It just keeps it organized. So I love it when litigants come in ready to go.
Well, that's good advice for people who use Venmo, to use the subject line.
Exactly. It makes our job easier.
Curtis Brown and Heather Palin are suing Heather's ex-husband, Scott Manis, for impound fees, harassment, and defamation.
Court come to order. All rise.
Have a seat, please.
Case 2142, Brown, Palin versus Mannings.
Thank you.
You're welcome.
Miss Palin, this is your former husband.
That is correct, Your Honor.
How long were you married?
18 years.
And this is your daughter.
Correct.
Is this your only child?
With Mr. Manis, it is.
Yes.
Yes.
You have other children?
One other, yes.
How old?
32.
When did you and Mr. Manis separate?
I moved out of the family home in March of 2018.
And this is your boyfriend?
Correct.
I'm going to, in broad strokes, at least try to reconcile both the complaint and the answer in this case. I assume there was a time when your daughter, whose first name is? Trisha was living with you after the separation.
We had a mutual divorce decree of 50-50.
And was that honored?
Until September 4th of 2020, Mr. Manis had brought Trisha back to my home. And while we were out of the home, he had her pack her belongings.
No, okay. Let's stop there. Trisha, how old are you?
I'm 19, Your Honor.
Okay. And right subsequent to the separation and the divorce, until September of 2020, you shared custody.
Correct.
Yes, ma'am.
And then Trisha decided she would prefer to live with her father.
Correct.
For whatever reason. I don't have to go into it, because this doesn't really have to do with who she chose to live with or where she was living. It has to do with a car. Okay. So while she was living with Mr. Manis purchased a car.
Yes, ma'am.
For her use.
Correct.
In what month did you purchase a car for her use? Month and year?
Oh boy, I believe that was probably February of 2019, I believe. 18 or 19.
Well, let's figure it out.
It was about 6 months prior to the case with her. So September 4th, we had the car. It would have been probably June or July of the same year.
So you bought her a car a couple of months before she decided to come and live with you?
Correct.
Okay, I got it.
She had just obtained her driver's license.
That's okay. I'm just trying to get a timetable. Right before she decided to come to live with you and not have 50-50 custody anymore, you purchased a car for her.
Correct.
And she drove that car in June or July, August?
Correct.
At your house?
At both houses.
She was allowed to go to take the
Yes,
car
ma'am.
to their house?
Correct.
When she saw her mother?
Yes.
And then bring it back?
Correct.
There was a time when you took the car away from her. When was that?
Probably mid-August.
Mid-August of 2020?
Correct. Well, the threat was to take the car away because her grades were slipping. I didn't actually take the car away.
When did you take it away?
I actually never did take it away. Her mother and her mother's boyfriend decided to purchase her another car to eliminate my threat of taking away the car.
Well, I don't know if that's because, but they decided to
Correct.
purchase another car. And what did you do with the car that you had gotten for your daughter?
I sold that.
When did you sell it?
Probably a month or so after she got the other car.
And the threat was made to your daughter because you were concerned about how she was doing in school or how she was doing socially. What were the reasons?
Well, her grades were slipping. Okay. So I wanted her to concentrate more on her grades rather than...
Grades were slipping?
Correct, at school.
Did she give you any reason for that?
She was under a lot of pressure with the divorce.
So you purchased a car, Mr. Brown and Ms. Palin, with the understanding, according to your complaint, that the car would remain in your name. There would be payments made on the car, and once the car was paid, it would transfer to Trisha. Well, one thing led to another. Things sort of went south. And according to what I've read in these papers, you got sort of annoyed. And the car that you had purchased was in the physical custody of Trisha, who was living with her father. And Mr. Manis caused the car to be towed and impounded, which caused you substantial expense to get the car out of impound. And he did that maliciously.
Correct.
And you want him to pay those expenses because you did, in fact, get the car out of impound, subsequently sold it. How much were the impound fees?
$1,565.22, Your Honor.
Okay. And Mr. Manis, in defense of that, acknowledges that he towed the car, your car. He towed the car, which was at your house?
Your Honor, I had
Where was the car?
The car at the time was at my house.
That's what I'm asking you. The car was at your house. You had it towed to impound. And you had it towed on what date, sir?
The car was impounded on September 4th.
Of what year?
2020, I believe.
And your defense for doing that?
Your Honor, he requested...
Your defense for doing that is that you were merely following Mr. Brown's instructions.
And the police officers.
You were following Mr. Brown's instructions.
Correct.
Yes, you have a police officer here.
I have several police reports, Your Honor.
About what?
This isn't just about the car. There's several years of harassment.
No, I'm dealing with the car.
I understand.
Right now, I'm dealing with the car.
So I have the several officers that came instructed us to get the car removed from the property.
Well, that may be, sir. You can have the car removed from the property and ask the police to have it deposited in front of their house.
I understand.
Yeah, you chose not to do that.
May I show you his request to have the car towed? He offered a reward for the car to be towed.
Just a second. I want you to tell me where I'm wrong so far.
And Heather Palin claim Heather's ex-husband, Scott Manis, owes for impound fees. Scott is countersuing Heather for filing a false CPS report.
Okay. You had the car towed to an impound. You did not call him or your ex-wife the day that you had the car towed to impound. It was some period of time later, if the fees for impound were $1,500. Your excuse for that is you were merely following his request. His request. That's what you wrote in your answer. Is that wrong?
No, Your Honor.
Okay. Well, so now we know that you didn't notify them when you had the car towed.
Your Honor.
Because you could have had the car towed to the local police precinct and called them and said, come pick up the car. It can't be in front of my house anymore.
Your Honor.
He was actually at my house that night.
Just a second. I didn't ask you anything.
Sorry.
Go ahead.
The police, when they came to our house, the car was present. They acknowledged the presence of the car.
You can't tell me what the police did, sir.
I have the reports, Your Honor.
I'd like to see, I will see the report. What I'm asking you is, there are two things. If you wanted the car out of your custody and you wanted to quietly and stop the friction, send it back to the people who purchased it, you could have done that. You chose not to do that.
Your Honor, the reason I chose not to do that is because of I have several false allegations from CPS, the police. I did not choose to have any contact with them.
You don't have to have any contact with them, sir.
In order to...
You don't have to have any contact with them. Just like you paid a tow truck company to take the car to impound, you pay the tow truck company, you live in a private house or an apartment.
Private house.
You have the tow truck company drop the car off in front of their house. Now, after you had the car towed to an impound company, did you contact them in any way?
No, I didn't.
No.
I was instructed.
Did you
not
ask
to
the
by
police to contact them and tell them?
The police knew, yes.
I didn't ask you what the police knew. You can't tell me what the police knew. So you had the car towed on September the 4th. And when were you notified the car was in impound?
I received certified letter on September 26th, which was a Friday. It said to contact them Monday through Friday between 8 and 4.
Just a second. You received that on September 26th.
Yes.
Is that the first notice that you had that the car was impounded?
Correct.
Yeah, that's the
Okay. So now the onus is upon you, Mr. Manis. I want you to prove your defense to me. And your defense was you were following Mr. Brown's instructions.
Yes, Your Honor.
Okay. That's all I want to see.
Here you go, Your Honor.
So this says $100 reward to anyone that impounds my car. Call a tow truck and tell them to contact me.
Yes, Your
You
Honor.
know this number.
Yes.
Yes. Well, did you do that?
The tow company sent them a letter on 9/10 of 2020, and I have the proof of that also, Your Honor.
Yeah, I would like to see what you're looking at. That's not on September 4th.
No.
That's not on September 4th.
9/10, they sent that out,
Okay.
the notice.
Let's see. Well, this says that attempts were made on 9/21, 9/26, and 10/5. That's what it looks like, attempts made.
That's when they had attempted to deliver, but they did not pick it up.
So they had no notice.
They had notice.
No,
did
they
not
had
pick it
no
up on
notice.
They
They
didn't pick
had
it up.
no notice.
If they would have gone to their post office box, they would have had notice.
If I had taller parents, I would have been 5'7". They had no notice. Okay, $1,565. That's what you owe them. It was a malicious act.
Your Honor, this isn't just about the car.
This is
There are
all.
horrendous
Listen to me.
False
This is all.
allegations through CPS. If you would please.
Let me. You have a counterclaim.
Yes, ma'am.
And your counterclaim I'm going to hear. Right now, you owe Mr. Brown $1,565 because what you did was malicious. And I don't understand something. You have one child together. I assume that you don't want to make her miserable. That when she was born, you said, oh, let's see what we can do over her lifetime to make her as unhappy as possible. Let's see what we can all do to make her as unhappy as possible. So I really don't understand two people who probably, in their own way, love their child, but hate each other more than they love their child, which to me is absolutely bizarre. So right now, because you did a malicious thing by having their car towed and not giving them a heads up that you had the car towed to a place that was going to cost them money, you owe them $1,565. Now I'm going to hear your claim that they made false charges to CPS about you.
Yes, ma'am.
Your Honor, can I say something?
About what?
The car.
Before you say anything, did I say anything that was inaccurate? Did your father have the car towed? The answer is he's acknowledged that. He had the car towed and put it in a place where neither your mother or her boyfriend knew where it was, resulting in their having to pay fines to get the car out. Is there anything that I said was wrong?
That is partially incorrect because I had contacted my mother in the time and asked either.
Okay, that I'll hear. You contacted your mother.
I did contact my mother previously, not only on normal messages, but also on messenger messages, including how I wanted either the title or my money back and that they could have the car before that. Once the Facebook post was...
All I want you to show me is that you notified either your mother or Mr. Brown that the car was impounded when you notified them.
She also did ask my best friend where it was.
All I want, that's all I want. Don't tell me what you said to your best friend who's not here. All I want to do is see where you notified your mother that the car was impounded.
So there is this one about money in my account, which was about the car.
I don't want to see anything about the car. I only want to see where you notified your mother or Mr. Brown that the car was impounded.
Okay. I don't have the text about that, but I did notify her that it was impounded.
Well, I don't know that, and it seems to me you weren't talking to your mother on a regular basis because there was a lot of acrimony. If you have it, you have it. If you don't have it, you don't have it. So, Tricia, you could sit down.
Defendant Scott Manis has accused his ex-wife, Heather Palin, of filing a false report with Child Protective Services.
Now, it was a malicious act to have the car impounded. There's no question in my mind that if they knew it was impounded, they would have gotten it out before. $1,565. Now, you want to show me what information you have with regard to filing a false CPS report?
Correct. I have the CPS reports and the police investigators report.
Okay. May I see it, please? This report, it was in September of 2020.
Yes, ma'am.
Okay.
It's been several years of these reports and
just
disgusting allegations.
Okay. So you filed or you made allegations to Child Protective Services?
CPS actually contacted me, Your Honor, regarding several calls that they had received for the welfare of my daughter, Tricia.
In what year?
I was contacted, I believe it was 2019, and again in 2020.
They contacted you?
Correct.
For what?
To do an interview because of a claim that was made regarding Tricia's safety.
That were made by an anonymous source?
I don't know who made them, Your Honor. In Minnesota, you can't make multiple reports by one person. I cannot call day after day to make reports.
I'm just asking you, did you at some point claim that you had reason to believe that your daughter was being in some way physically abused by her father? That's either a yes or a no.
Yes, to a point.
Yeah, okay. And part of that involved a sexual abuse.
That one was not claimed by me. I did state to CPS that he does have her sleep in his bed with him.
Well, I have to tell you something.
Which is a little weird.
I have to tell you something. That doesn't seem a little weird. It seems a lot weird that your daughter acknowledged, sir.
Your Honor?
Your daughter. What I'm telling you is, it is inappropriate for a man to sleep in the same bed as his 15-year-old daughter.
Your Honor,
that's
we went
my
to a
view.
concert.
And if that's true, there may be a reasonable explanation for it. She said she was scared, whatever, but when interviewed, that's what it says in here. But I'm telling you, as a mother and a grandmother, in my view, and I'm not a professional psychiatrist or psychologist, but it is inappropriate for a teenager to sleep in the same bed with her father. Period. Maybe some countries it's appropriate, but I...
Your Honor, we went to a concert.
What?
And shared a hotel room at a...
No, that's not what your daughter said. No. That's not what your daughter said, sir.
May I finish?
Yes.
When she was going through all the stuff with the divorce and everything, she came into my room. I was asleep. She laid next to me. I'm asleep.
Listen to me. I'm not suggesting
Honor,
that
there's
anything
nothing
inappropriate... Sir,
absolutely right.
understand this. I'm not suggesting that any inappropriate actions happen between you and your daughter. I'm telling you that it is inappropriate, the act of sharing a bed with a teenage female child as a father would give me cause to pause. I would say, you know what? That's not a good idea. It's especially, sweetheart, it's especially not a good idea when parents seem to be feuding. It's grist for the mill. You may want to go and, if she's scared, say, sweetheart, I'll go and sit in a chair in your room.
Many times.
In your room.
Many times.
But please, this is inappropriate. Do you understand? It's inappropriate.
Did you read the detective's statements in there?
No, I'm not interested in the detective statements.
Obviously.
If what your daughter says is true as a result of the investigation, then there was reason for somebody to suggest to CPS to do an investigation. So, listen, bottom line, I can't tell the two of you to stop feuding. I can't. You either hate each other more than you love your daughter. That's the answer. And this court can't fix that. All I can do is fix $1,565, which is what you owe them for impound fees. This case is over. Thank you.
This court is adjourned.
I think the judge is wrong.
I am thankful for the judge.
She didn't read all the evidence. Multiple pages weren't read.
He's very good at manipulating others.
And multiple accusations.
And being the person that, oh, pity me, feel sorry for me.
False allegations to the CPS.
My ex-husband decided that he would show me.
No, he was trying to get my daughter her money back or the title to her car.
He actually had the car as of August 24th. Then he brought her to the house and moved her out on September 4th. And that's when it just started going downhill.
She has a lot of hatred.
I believe he's very angry that I divorced him.
That she falls off a bridge.
And he lost the control over me that he had while we were married.
You know, Sarah, I've been doing these family cases for very, probably 40 plus years. And it always makes me sad that the mother, the father, even the new boyfriend, there is a window in life when you feel relatively healthy, nothing hurts you, you don't have a bad back, you don't have to worry about indigestion, you can walk around without a walker, you look pretty reasonable, and that you will take years away from that good time to create negativity around not only yourself, but the people that you love.
I think that's great advice.
I always said to people, both men and women, that, it's one journey. You can take that journey and put as much positive energy into it.
Yeah, I just felt bad for the daughter. I mean, I know she's grown now, 19, but still 19, it still hurts your feelings to hear and see that your parents hate each other more than they care and love about you.
Well, maybe that statement
will make a difference. You never know.
Make a difference, because I'm sure it's not true.
Yeah.
I have a feeling.
But when it's said to you in a court in front of your child, hopefully they take some action on it then.
Well, hopefully they'll say, boing, I mean, she has a new boyfriend, and he's got his daughter who's living with him. They should be happy.
Yeah.
And they're divorced.
Close the book and move on.
Close the book.
Yeah.
Her mother and her boyfriend should get a puppy together. Well, they should not until they get married. Not until they. But do something. This is a grown young woman.
Have a healthy adult relationship with your adult child.
Right. Yeah. Not over a car. But teenagers do crazy things for a car. I think that some teenagers would live with Satan if they bought him a.
Hello, xin chào các bạn. Cảm ơn mọi người đã luôn ủng hộ kênh của mình nha. Ngày hôm nay mình sẽ hướng dẫn các bạn tô một bức tranh cô gái mặc chiếc áo rất là ấm này. Mái tóc này mình sẽ tô màu cam nha. Vậy là chỉ với ít phút mình đã hoàn thành xong rồi đây này. Các bạn hãy cho mình biết ý kiến của các bạn ở dưới phần bình luận nha. Video của mình sẽ được kết thúc tại đây. Bây giờ đừng quên nhấn like và follow kênh ủng hộ mình nhé. Xin chào và hẹn gặp lại.